All right, we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts of the Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, and good morning, and welcome to the Massachusetts Appeals Court oral argument session for June 3rd, 2021. As you know, the argument is being held on Zoom and live streamed on the Appeals Court's YouTube channel. The panel for today is Justice Peter Sachs, Justice Sabita Singh, and myself, Greg Massing. We will follow the same rules and as customs as in the physical courtroom, except you may feel free to remain seated while you're speaking. Once we get going, the session clerk will display a countdown clock, and each side has 15 minutes to argue, as always, and there's no rebuttal. You're welcome to use all your time, but there's no penalty for finishing early. Only one advocate will speak at the time. We'll ask you to be muted when you're not speaking, but since we can still see you, please keep your reactions to a minimum. The proceeding is being recorded and archived and will be accessible to the public. As always, we've read your briefs and we're familiar with the case. In fact, we have your briefs and record materials on our computers and tablets, so if you see us looking away, it's not that we're distracted or not paying attention to you, but we're looking at case materials. So with that, I'll call the first case, which is Commonwealth versus Marcus Cooper, 2019 P1806. And Attorney Minkin.
Good morning. May it please the court, Michelle Mencken on behalf of Marcus Cooper. The fact that there was no photograph on the phone was a big problem for the Commonwealth. Wesley makes it clear that you have to look at the photo to determine whether Section 105 has been violated.
Wait, so what makes it clear that you have to look at the photo?
Commonwealth versus Wesley, SJC case, cited in my brief. I can give you the site.
I know, I just didn't hear what you said.
Oh, okay.
How does, that was my first question, is that the statute says whoever willfully photographs. It seems like it makes the verb illegal, it doesn't require producing a photograph. So what is it about Wesley that says you need to produce a photograph?
Well, the statute does specify what content is prohibited. So it's not just who photographs anything, it's who photographs a person who's nude or partially nude. And the implication of Wesley is, so the court looked at these photos and said, okay, well, here are photos that don't violate the statute. These are photos that exist, but they don't violate the portion of the statute with which the defendant was charged for various reasons. One was the subject was actually nude. So since that defendant had been charged with taking a photo under and around clothing, that photo, even though it was offensive in nature, did not violate the provision of the statute with which the defendant had been charged. Therefore, there was insufficient evidence found. And we can take from that, if it's not already clear from the plain language of the statute, that a photograph of something other than a person who is nude or partially nude wouldn't violate the provision of the statute with which Cooper was charged. It would have to be a photograph that reflected an image of a person who was nude or partially nude.
So if the jury believed that the cell phone had been stuck up over the top of the stall door and angled downward, couldn't the jury, using its experience and common sense regarding cell phone cameras, infer beyond a reasonable doubt that it captured a photograph of at least part of the victim?
Well, no, I don't think that that's such a common sense inference. I mean, it's certainly not been my common experience that I always am able to capture what I'm trying to capture with a phone, and particularly when there's no evidence that Mr. Cooper could see what he was photographing. So we have a phone that is up beyond his
again,
vision.
can't the jury infer if he's 5'10", as the victim testified, I think, and if the stall door is 6 feet, then the face of the screen of the phone is not very far above him, and can't the jury infer that he can see it?
I don't think, I would disagree that that's a natural conclusion. I think it depends upon the angle at which the phone is tilted. So, and we don't have sort of the dimensions of the stall. I don't think that just holding a phone up this thusly would necessarily capture what was over the door at, if she was squatting.
Yeah.
I
Well,
don't
if the jury believed that this was all accidental on his part, then they might have a question about what the phone captured. But if they believed that, it was highly implausible that he went into the women's room by accident and then held up his phone over the stall door by accident, if they inferred that it was purposeful, then they could also infer that he aimed it to try to capture what he was looking for.
And the operative word in Your Honor's construction there is to try to capture. I think it's not a foregone conclusion that he successfully captured, and that would be required for conviction, because of course—
You're saying, sorry, so you're saying that in any such case, we would have to, in this kind of a case, we would need a photograph, even which depicts a person in a state of nudity or partial nudity. The photograph would have to depict that.
I think you have to have evidence that such a photograph existed. So in the unpublished Clark decision that is appended to my brief, there was evidence that the witnesses saw the images and saw the person delete the images. And I think that in that case, an argument could certainly be made that there was proof that such a photograph existed, that the photographer was guilty of having captured an image because somebody saw the image. Likewise, if the circumstances, so I'll take an example that's not a photograph. So let's say that it's wiretapping. I mean, we know from wiretapping jurisprudence that there has to be an actual interception of communications. There's a case called Wright where there was an effort at interception, but the sound was completely garbled and that didn't cut it. So, but a microphone, let's say that there's a microphone trying to intercept communications. I think it's easier to infer from the circumstances of the placement of a microphone that it captured what was aimed to be captured than a camera that is being pointed beyond the vision of the person who's trying to, it's kind of like luck. Like I'm hoping that this is pointing at what I'm trying to get, but I don't know if it actually did it.
So under the words of the statute, is it enough? Would it be enough if there were a photograph showing the victim's face and not any lower part of her body?
That's a very valid question and one that I've looked at, and I don't know that that is answered by case law or statutory language. I mean, I think that—
Well, it seems to be answered by the statutory language. Whoever willfully photographs another person who is nude or partially nude.
So
it doesn't say, as the statute in Wasserly does, the statute in Wasserly says secret photography of, quote, the sexual or other intimate parts of a child under the age 18. Under or around the child's clothing. So it seems by comparison to 105B, paragraph 3, which requires that the photograph actually capture the sexual or other intimate parts, that 105A or 105B, sorry, paragraph 1 says the person who is nude or partially nude.
that's right. I mean, I follow that argument. So there's certainly an argument to be made, which you've just made, which is that a photograph of Bannon's shoes would violate the statute. There is a distinction in the language of the paragraph that you just read, which is that it does include an effort, an attempt to view the person's sexual or other intimate parts, which is an important distinction, which is not present in our paragraph. And I think that, there's on the flip side, there's an argument to be made that the legislative intent was to criminalize, capturing an image of something very private, the state of nudity. But that question does not need to be answered in this case because we don't even know if a photograph of Bannon's shoes or hair or anything was successfully captured. And there's not enough information from which to infer it. Even if you take everything that she says and you take all the circumstantial evidence, what you have is an effort at doing it and no more. And that doesn't suffice.
Well, on direct, she says, I think a noise, a non-distinct sound could have been a camera click. And then I think on cross, she says she thought it was a click. So why isn't the click enough?
Because he can't see what he's looking at. And so he doesn't know whether
Okay, so is the click enough to allow the jury to find that a photograph was taken? Start there.
well, that an effort to, I think that it's enough for the jury to infer that this was an effort to take a photograph. But things go wrong with their
But if you hear the click, then what has gone wrong?
So fair enough, a photograph, something may have been, a photograph may have been taken, but we don't know what it was. Did the flash bounce off and obscure completely any image? Did he capture just the stall wall? Did he capture the back of the toilet?
So could the jury infer, if they found the story of wandering into the women's room while distracted on the phone implausible, couldn't they infer that the defendant delayed going to the campus police station for the specific purpose of taking time to erase the photo or transfer it using the Photo Vault app or whatever he did with it?
So this is very, our position is that no, there wasn't enough there. And there is support for that position in case law, for example, around around armed robbery, I should say. So it matters really what the opportunity to delete is. And I just want to say, I don't want to get too caught up in the lack of evidence of deletion here, because there's also this other issue, of course, which is that the phone had been searched and no evidence of deletion was found.
Well, I wanted to ask you about that. You say that the Commonwealth exploited the motion to suppress by making that argument. But I mean, there was the evidence of this, the jury doesn't know about this Photo Vault app. I mean, you say it's conclusive they didn't find a photo, but wasn't there evidence that he might have used this photo, this app to delete a photo, which he had accessed during that 15 minutes, apparently.
Apparently, that Photo Vault app had been accessed, and that was apparently as far as the evidence went. So again, it's speculation and inference to try to figure out what was the purpose of that. The phone was searched for deleted items and no deleted items were found. They also, the suspicion, according to this transcript of the motion to suppress, the suspicion was that a photo may have been uploaded to the internet from that app. And again, no evidence of that was found. And in any event, the bottom line is none of this was presented to the jury. So there is significant evidence that undercuts the theory that this has been deleted, which is unknown to the jury. And I think it's entirely unethical and unfair for the case to rest upon that when significant evidence undercutting the theory wasn't presented. And why wasn't it presented? I mean, if that was so great for the Commonwealth that this photo app vault thing had been accessed and it wasn't excluded under the suppression order, why wasn't it?
Well, one could ask why the defendant didn't present evidence that the search of the phone of the photographs had been done and no actual or deleted photographs were found.
Absolutely, he could have.
Yeah.
Absolutely.
And it's the same reason that probably neither side wants the other side to be able to come back. The defense doesn't want the Commonwealth to be able to come back and say, oh, but this Photo Vault app, and the Commonwealth doesn't want to mess around with this Photo Vault app evidence because the defendant comes back and says, yeah, but you looked at the photo folders and you found nothing there and nothing deleted.
Sure. And if all of that had been done and then somebody turned to the jury and said, what do you think? Deleted or not deleted? Fair trial. But what happened here was not fair. I think that the jury would have had to have inferred that the thing had been deleted. And I was just reaching for a site. It's actually a concurrence, but by Justice O'Connor in one of the armed robbery cases. But the point is that an opportunity to delete something is as consistent with non-deletion as deletion. I mean, this is nobody, unlike Clark, nobody saw an effort to delete. Nobody saw something exist before and then suddenly not be there. Defendant didn't say, I'm going to delete this, or, now you see it, now you don't. There is nothing other than this opportunity. So it's almost entirely speculative. And our position is that that is not enough. And especially where we have this contrary evidence, it's just not a fair inference for this entire case to hinge upon. So that's our position on that. I see my time is almost up. So if there are no other questions, I'll rest on my brief on the other points, including the closing argument, which I would say, even if this court finds that the jury could have inferred from what was there, you have to consider that judgment that it ultimately made was very likely swayed by improper considerations, burden shifting, vouching, this business about calling the hallway an alcove to make it sound like Cooper was doing nothing but hanging around the ladies' room for an extended period of time, which was inaccurate, means that you can't, that the verdict still can't be relied upon. Thank you.
Right. Thank you very much. We'll hear from Attorney Huftring.
Morning, may it please the court, Susan Offstring on behalf of the Commonwealth. The Commonwealth asks that this court affirm the defendant's convictions where the judge properly denied the defendant's motion for required finding of not guilty, where the evidence and reasonable inferences drawn, viewed in the light most favorable to the Commonwealth, supported the convictions. Wasserly says what the legislative intent was of the statute, and that's to protect the victim's privacy and to penalize the invasion of that privacy. And that's exactly what occurred in this case. The evidence, the totality of the evidence, but focusing for the moment on just the happening of the crime, showed that the victim went into the ladies' room. She said her testimony was she was the only one in the ladies' room, went into the stall, closed the door, took down her pants, and then saw a shadow, a man's shoe. And I think her testimony knows it wasn't a split second. She then was able to look up. Her testimony was clear that she saw the lens of a cell phone camera pointing at her. And her words were peering into the stall with the lens pointed at her. She was clearly partially nude. She then heard the click. And as Your Honor pointed out, the evidence was that the defendant was 5'10". The jury could see the defendant's height at trial. They could see it in the video. They knew obviously the victim's height. I think she said she was 5'4". The stall was 6 feet high, and a reasonable inference based on just that evidence alone was sufficient to convict the defendant beyond a reasonable doubt. But the Commonwealth had more evidence. And
I mean, can I stop you there? Like, I mean, how do you know that he did successfully photograph the victim? You know, that the click went off at the exact right time. That they're, how do you know that he photographed her without a photograph?
Well, I think it's just an inference in the light most favorable to the Commonwealth, with the camera being pointed at her and hearing what sounded like a click, whether it was an actual photograph or he's seeing the screen side of the phone to determine what he's taking a picture of.
Well, I mean, that seems sort of implausible that he could see the screen side. From my knowledge of cell phones, if he's pointing it into the stall, there's no way he can see the screen.
Yeah, I don't agree with that, Your Honor. I do think reenacting it, even a jury could reenact it with themselves, given the defendant's height. It was a mere 2 inches, really, to get over it wasn't into the stall. The victim was very clear, and I think the defense attorney tried to get her to say, well, the phone was over the edge of the stall into the stall, kind of implying that he couldn't have seen what was on it. But she was very clear that she saw this black knuckle holding the phone at the top of the stall. So we're only talking 2 inches from his height. And I would say that holding a phone with that, you don't have to point the camera all the way down. It's a sufficient angle for him to be able to see what's on the screen side. And I think the jury could reasonably infer that a photo was taken, again, in light of not only what happened in the restroom, but what happened after. He refused to let the victim see the phone. He refused to identify himself. He told her, if you knew who I was, you wouldn't be doing this. He refused to go to security. Now, he gave a different statement to police. The jury was not required to accept that. They could have, and again, in light most favorable to the Commonwealth, accepted the victim's testimony that he, and we have it on video, running fast through the building to get into his car and leave.
Isn't all of the consciousness of guilt evidence, and even taking 15 minutes to get, or 13 minutes to get to the police station to leave himself time to look at his phone, equally consistent with him not being sure whether he captured an image? He may well have been trying to, but this wasn't an attempt case. He didn't know whether he'd gotten one or not. He ran away because he knew that perhaps that what he had done was improper at a minimum. Then when he gets to his car and looks at his phone, says, lo and behold, I don't have a photo here after all. And he's perfectly happy at that point to turn the phone over to the officer at the campus police station to look at and see that there's no picture.
It was a fair inference for the jury to find, and I think if they determined that there was no photograph, that they wouldn't have convicted. But I think the inference, and again, in the light most favorable to the Commonwealth, is that he knew he had a photograph. That's why he didn't want to show his phone. Again, this is something the jury could infer. He refused to, he took out his phone initially, and I think her words were engaged it right when she confronted him, either in the restroom or in the hallway, and refused to show her.
Because he may not have known at that point. I guess my question is it an equally plausible inference that he didn't get a photograph? And where it's an equally plausible inference, then can the taking of the photograph be said to be proven beyond a reasonable doubt?
I don't think it's equally plausible. I think it's more likely that he could see the screen. He knew from where he was, how close he was to the stall. This is not where he was from a distance. She saw his shoe at the bottom of the stall, saw the shadow, saw the phone pointed at her. And again,
but that doesn't go to whether he succeeded in taking the photographs.
No, and to that point, I don't think the statute requires that we have to prove an actual photograph. And I did come across an unpublished case that I would be happy to send in with a 16L letter, Commonwealth versus Famosi, F-A-M-O-S-I, from this court. It's an unpublished case, February 8, 2021. But the issue in that case was it was the third paragraph of the statute of under the clothing. And they said that was the Commonwealth didn't produce sufficient evidence on that, and therefore they reversed the conviction. But the defense also argued that the Commonwealth failed to produce a photograph or a video electronic surveillance in that case. And this court said that that they disagreed that the photograph was required, that a jury's verdict based upon direct evidence on the one or more elements, they conclude that without a photograph or a video, it was sufficient for the fact finder to infer that the defendant used an electronic device to secretly surveil the 17-year-old victim. Again, it's an unpublished case. I'll be happy to submit it. In one other case I read, and I wasn't going to mention it today until my sister brought up a similar fact or analogous, I guess, with the wiretap statute, saying that you have to prove that there was a recording. And again, I just happened to find the case, I think it was yesterday, and it's not in my brief, but it's Commonwealth versus Manzilli, MANZELLI, 68 Mass Appellate Court 691. And that case is about the unlawful electronic interception of oral communications. And there the court said that the lack of a tape, you can still get a conviction with ample circumstantial evidence that the defendant possessed the device that was capable of recording in the odd manner in which the defendant responded to the allegations, how he discarded the tape. So just even under that statute, the unlawful interception of oral communications, a tape existing is not required. And I would suggest that the same under this statute. The purpose of the statute is to protect the privacy of a victim. And in this case, I don't know if you can get much more of a private setting. When she's in the women's room, the defendant followed her in for after, and based on the circumstantial evidence of what the defendant was doing in the 11 to 12 minutes prior to the crime and what he did after the crime. And the totality of all those circumstances, reasonable inferences, and direct evidence, the jury had ample evidence to convict the defendant of these crimes.
Can you address? Go ahead, Jesse.
Was this case tried on a theory that he could be convicted even if no actual photograph was taken? In other words, just by the surveillance aspect of it?
I'd say that the main focus was that there was a photograph taken. He just either deleted it in the time that he left the campus until he went back to the police station. But the jury was also instructed, and I didn't put in my brief, and I apologize, but the defense, even in his proposed instruction, as the trial court pointed out, included language about electronic surveillance. So although it wasn't the main theory to the case, the jury nevertheless had the instructions read to them twice. And again, defense counsel had it in his proposed instruction of electronic surveillance. And that, unlike the photographing, electronically surveillance, as you know, is defined in the statute to view with a cellular device. And I think that's an inference that the jury, with the evidence presented and the instructions that they had, could have inferred that there was some type of, and even if it's the split second before he hits the click button, if he can see the screen and he's electronically surveilling what image he sees, and then he presses the click button, you may have both the electronic surveillance and a photograph.
I was going to ask you if you would to address the closing argument about the victim having no motive to lie, especially when the defense wasn't that she was lying, but that she was, that she was mistaken.
I think it was still a proper argument. The defense did suggest in his closing that she was not credible. He mostly focused that she was maybe not that as reliable, it was all mistaken, but he did touch upon, and I cited the page in my brief, I want to say page 222, that she wasn't credible. So I think just by saying that, it allowed the prosecutor to explain, based on the evidence, why this victim, what was her motivation and why she was credible to the jury based on what she saw, and even with the inconsistencies. She didn't remember everything, that she may have said something to the police and not. So I don't see it as an error, and nevertheless, the judge gave I think, more than a few curative instructions. Some I don't, as I mentioned in my brief, I think were more beneficial to the defendant and maybe not warranted. And for all those reasons, I think that the jury did weighed the evidence, evaluated the evidence, and the defendant had a fair trial.
And I want to ask you about your argument on the disorderly. It seems to me that your argument would make every like open and gross, every lewd and lascivious, every instance of this statute disorderly conduct as well. And doesn't that go a little bit above what disorderly is? If
I did that, I apologize. I didn't mean to do that. I think I was trying to focus on voyeurism and the facts of this case. So I mean,
Lepore was written before this statute was enacted. There was no peeping Tom law, and so now we have a specific one. But do you think this covers all the action here covered all the elements of disorderly conduct?
I'm not going to say that every violation of the statute would cover the elements of disorderly, but I think in the terms of this, what happened in this case and the totality of the evidence that was presented, it is covered under that statute. And I didn't mean to apply that all of it.
Isn't like the just flashing somebody, wouldn't that be the same? Isn't that the same? The argument you're making here with respect to this, like it caused alarm or shock or whatever.
I don't think I followed the question. I'm sorry.
Okay, well, so you didn't mean to. So tell me what is specifically about this act that would distinguish it from, say, just a flashing.
Well, I'm just saying in this case, with the defendant going into the ladies' room, disrupting the victim who has an expectation of privacy as voyeurism or a peeping Tom, causing her alarm, distress. She runs out. They're running through the school. Another person's involved. It's a public disruption caused by an act that the defendant did, and therefore it violated the statute.
All right, your time is up. Any other questions? Seeing none, so either one of you, if you want to write a 16L letter with giving us cases and no argument, you of course have you do that under the rule. So we'll take the case under advisement. Thank you both very much. Very well briefed, very well argued. You both did a great job.
Hold on one moment. I will confirm once we are live. All right, we are live and on the record.
Thank you. Good morning and welcome to the Massachusetts Appeals Court oral argument session for June 3, 2021. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. The panel for today is Justice Peter Sachs, Justice Sabita Singh, and myself, Greg Massing. We'll follow the same rules and customs as in the physical courtroom, except feel free to remain seated while you're speaking. Once we get started, the session clerk will display a countdown clock where the court insignia is. As you know, each side gets 15 minutes. There's no rebuttal. You're welcome to use all your time, but there's no penalty for finishing early. We'll ask the person who's not speaking to mute themselves, but we also ask you to stay on the screen so we can still see you're there. But since we can see you, please keep your reactions to a minimum. As always, we've read your briefs and we're familiar with the case. In fact, we have your briefs and record materials on our computers and laptops and tablets nearby. So if you see us looking away, it's not that we're distracted, it's that we're actually looking at case materials. So with that, I'm going to call this case, which is Commonwealth versus Privette, 2020 P251. And we'll hear from, is it Roussev?
Yes, that's right.
You have the floor.
Thank you so much. Good morning, and may it please the court. My name is Anne Roussev, and I represent David Privette. This case is an interlocutory appeal from the denial of a motion to suppress. And the issue before this court is whether, based on a detailed description of a Black male suspect, there's reasonable suspicion to support the stop of a Black man walking down the street in Dorchester, whose appearance varied from the description in 6 major respects: his height, the color of his shirt, the style of his shirt, the color of his pants, the presence of an undescribed red plaid backpack, and most notably, the presence of an undescribed noticeable beard. The amount of detail.
Let's get to the facial hair.
Yes.
It seems to me Doherty's testimony was internally contradictory. At transcript 20 and 29 to 30, he says the description included facial hair. And when we listen to the Channel 6 recording, it meant that not the first description, but the second description that goes out over Channel 6 mentions facial hair. But then at transcript 38, 39, a recording is played by defense counsel that doesn't include facial hair. Counsel asks, is that all the information you had? And Doherty says yes. So there's a contradiction in his testimony. The judge does not resolve that. My question is, can we resolve that by invoking the collective knowledge doctrine? Because there's also testimony that I guess then Sergeant, now Lieutenant Dwan, knew of that description as he was en route to the scene.
I think that the judge did resolve it because in her findings, she did not include the beard in the description. So the only findings that we have from the judge are that this description did not include the beard. And there's
but she didn't, what she says is there was no mention in the original broadcast about facial hair. She does not find that Doherty did not know of the facial hair. She finds Doherty credible. She does not address the contradiction in his testimony. So I don't see where she resolved this issue.
Well, where there is contradiction, I think her findings do resolve it because she doesn't say that Doherty heard the beard. If she had believed that, that would have been in her findings about the description, but she specifically excludes that and then drops the footnote about that description not being in.
Okay. Well, if we don't treat that as a resolution of the issue, I mean, clearly, if she said no, he didn't know, then we would be stuck with that finding unless it was clearly erroneous. But if we don't think she resolved it, would the collective knowledge doctrine resolve it in the Commonwealth's favor?
I don't think so, because again, she makes no findings about what Dwan knew or didn't know prior to the stop.
Okay, but she credits Dwan. His testimony is that he knew about it. There's no contrary testimony, and the turret tape recording supports that. So why, under Jones-Pennell and Isaiah I, couldn't we supplement her findings with the finding that Dwan knew?
I think Dwan's testimony is not as clear. He does say that he received a description. He said that he believed that the description included facial hair, but without findings from the judge, when we have an explicit finding that the original description did not include the beard, and then she doesn't make any findings based on Dwan's testimony, I think that you can't then do appellate fact finding, find that Dwan knew and when he knew, because we don't have that specific information based on the judge's finding. I don't think that the collective knowledge doctrine is implicated here, because we don't normally in collective knowledge doctrine cases, you have specific findings from the court. You have Officer A knew this, Officer B knew this, and I find that they were working together in close concert, and therefore we can aggregate this information. You just don't have those factual findings here to support that.
So if we view the contradiction as unresolved, and if we can't resolve it through the collective knowledge doctrine, should we remand for the judge to resolve it?
No, I think the court can make the determination based on the findings we have from the judge. The judge did not find that the beard was in the original description and goes on to analyze the case as though the beard was not, that Doherty did not know about the beard. So I think you can resolve it on those facts and find that there is not reasonable suspicion because of all of these variances in the description.
I noticed that in your brief, you did not, and your reply brief, you did not make anything of whether the defendant actually had a medium build or not. And the booking sheet describes him as 5'11" and 220. Is there a reason for that?
I think that a medium build is so broad that I don't think I can say in good faith that that could not potentially be considered a medium build. But I think that that is not distinctive enough to get us close to reasonable suspicion, especially when we have the more detailed information about the height, and Mr. Privette is clearly taller than 5'7". He's 5'11". And we have the details about the color of the hoodie. And then we know that Mr. Privette was not wearing a hoodie and that he was wearing a green sweater. So I didn't address the medium build because I don't think that there's enough daylight between 5'11", 220 and a medium build, but I don't think that that is distinctive enough to add to reasonable suspicion, especially where you have all of these other discrepancies.
But what about the fact that, suppose that there was a fairly, this is a fairly vague description. Let's make it even vaguer. There's a description for there's been an armed robbery. There's a man in his 20s, 5'7", 5'8", medium build, jeans and a hoodie, and of course you can, and then there's a man roughly meeting those description. The thing is, though, it's 3:35 in the morning, and there's nobody else around, and this is in the flight path of the, in the flight path from the gas station. Why is it not just good police work to question the only person who's around?
Well, the police certainly could have tried to engage him in conversation without affecting an immediate non-consensual stop, but that's not what they chose to do here. Certainly, I think police work would involve continuing the investigation when they see Mr. Privette, but they decided to make a stop, and that stop requires justification. In terms of Mr. Privette being the only person present, I think that's clearly a factor, but it's not in any way dispositive. We know from Martinez and Warren that that is not a dispositive factor. Those were two cases where the defendants were the only people present in a deserted area, and that was still insufficient for reasonable suspicion. So you need
being present in a deserted area a mile from the crime scene, as in Warren, and 700 feet from the crime scene here seem to be two quite different things. And here it was 6 or 7 minutes after the crime. In Warren, I believe it was half an hour or
yes,
an hour.
That's correct.
So if you're talking about a dragnet, this case where there's the only person on the street that close temporarily and physically to the crime, it seems like there's not a dragnet here.
Well, in terms of the proximity, certainly someone who is fleeing the scene of a serious crime could have gone a lot farther than 2 blocks in 7 minutes, certainly.
Yeah.
And if I could return to the fact that Mr. Privette was the only person present for a moment, in the cases that really rely on this factor heavily, there's something particular about the nature of the area or the weather that would make it surprising to see someone. And we simply don't have that here. This is not.
It was raining, and
raining.
None of the other officers, but not only Doherty, but Duan and Lopez, although they didn't canvass the entire area, particularly on the other side of Morrissey Boulevard, they were on Morrissey Boulevard, or at least the Duan and Lopez were on Morrissey Boulevard at different times. None of them saw anyone. This defendant was the only person they saw.
That's right, in about the 7 minutes, but it's not as though this is a deserted commercial zone. Like in the White case where there are just no pedestrians expected. It's not as though, let's be honest, this is Boston. This is not San Diego. People do go out in the rain. This is not like the McCoy case.
But nobody else did go out in the rain.
Certainly, but I think there's nothing about Mr. Privette's behavior that suggests he's connected with the crime. When the police first see him, what is he doing? He's walking down the street at a normal pace. When the police interact with him, he's completely compliant and cooperative. So just like in Jones, there's nothing about his behavior that suggests that he is either fleeing from a crime or trying to conceal himself or is in any way connected to a crime. So without something else, aside from him walking down the street in this area, there's nothing particular to him that suggests that he's fleeing the scene of this robbery. And where we have an area that's a mix of homes, of businesses that, we know for a fact the gas station was open at this time of night. There's a CVS pharmacy down the street. Pharmacy is a type of business that's commonly open 24 hours. There's also the Chinese restaurant. So this is not an area where there's simply nothing open at this time of night. So I think that factor is not, can't be weighted that heavily here. especially where there were enough details in this description to know that the caller got a good look at the person. We know that the caller saw the suspect from behind because he gives a direction of flight.
Can I just go back for a second to what you were just talking about, saying with the CVS perhaps being open, the Chinese restaurant, who knows, but this was an area where there might be businesses that were open, but in addition to the gas station. Doesn't that, if anything, strengthen the inference that the sole person found on the street was connected to the robbery? Because if these businesses were open and there were lots of people on the street, then it might make it more difficult to single out someone and say, we suspect you of the robbery. But the fact that these businesses were open, yet there was no one else on the street, seems to cut the other way. Maybe I'm not clear. Maybe we're two ships passing in the night here.
I think we might be. I think the fact that there are businesses open means that there are legitimate reasons to be out and about. So there's nothing about Mr. Privette's presence in and of itself that is suspicious. Unlike the cases like McCoy or White, where it is surprising and unexpected for the officers to see someone in that particular area, either because it's an incredibly blustery, slushy night, or because it's a deserted commercial area where there just simply are no pedestrians. So there's nothing inherently suspicious about his presence there. And then when you add in the fact that we have these voluminous details about the type of clothing that the caller describes, and Mr. Privette does not match that, then that further erodes any reasonableness of the suspicion. And I think the Commonwealth's position seems to be that no description is required at all. And putting aside, and so that any discrepancies are immaterial. I think putting aside whether that argument stretches Article 14 past the breaking point, I think that it also starts from a false premise, because this is not a case with no description or a very vague description. I think having the height, the color, the style of the clothing, all of those things is actually a very full description. And so in each of these facets that Mr. Privette doesn't meet this description, it actually serves to exclude him from the universe of possible suspects. And
how much weight can we give to the hoodie versus sweater a discrepancy, where it's quite easy to remove the top part of your clothing and either put on something else or reveal what's under? I mean, if that is enough to exclude him, then anybody who wants to commit an armed robbery or other crime, they just need to, take off the top layer of the top half of their clothing, and then they don't meet the description anymore.
Sure, and I think that would be the case if that was the only discrepancy. But we don't have that. We also have the difference in height. We have the green sweater versus the blue hoodie. We have the blue jeans versus the black jeans. We have the presence of the red plaid backpack, and we have the presence of the beard. So all of these things taken together make it unlikely that Mr. Privette was the robber. It's a much different situation than if there was just one thing that was wrong. Of course, the cases are clear that the courts are not going to require a full matchup between the suspect description and the defendant's appearance. But where you have a discrepancy on every aspect except for race and gender, I think that has to fall below the threshold for reasonable suspicion.
So you said before that we couldn't apply the collective knowledge doctrine without findings on the issue. Is that a rule of law supported by the cases, or is that well, let me just ask that question.
I think that to apply the collective knowledge doctrine, of course, it wasn't raised, it wasn't argued, it's not been briefed. So I don't think that it's, the judge didn't have an opportunity to make those specific facts, to make those specific factual findings. Well, I suppose she did have an opportunity, but she did not make those findings. So there's just not a basis to supply those missing facts, which would be what officer knew what and when they knew it, and then to make a finding that would be required that these are officers that are working together in close proximity within arm's reach in a joint investigation, and that therefore it's fair to aggregate it. That's a series of factual issues that have not been established. And so I think the factual predicate is just not here to apply the collective knowledge doctrine.
Thank you.
Thank you so much.
Thank you very much. We'll hear from the Commonwealth.
Thank you. Good morning. May it please the court. Assistant District Attorney Daniel Nucci on behalf of the Commonwealth, asking this court to affirm the motion judge's denial of the motion to suppress. The stop of Mr. Privette on August 12th of 2018 was proper because there was reasonable suspicion to stop him that was grounded in specific and articulable facts and the reasonable inferences drawn from. The reasonable suspicion here is based primarily on 6 factors. First being the description, including that updated broadcast that is in question. The original 911 call came in at 3:35 a.m. and the initial description went out 1 minute later at 3:36 of a black male, late 20s, between 5'7", 5'8" in height, and wearing dark clothes and a blue hoodie. Officer Doherty received that dispatch while he was canvassing the area. While he's continuing to canvass the area that he's very familiar with, at 3:38, an updated dispatch comes in of a black male, 28 to 29, medium build, 5'7" to 5'8", blue hoodie, blue jeans with facial hair.
So what do we do with the discrepancy between in Officer Doherty's testimony and the fact that the judge didn't explicitly resolve it?
So I would ask the court to take that collective knowledge doctrine into consideration here. Lieutenant, then Sergeant Dwan, did state he heard that description. He had the understanding that the suspect had a beard. Officer Doherty, I believe at transcript page 17 and 18, mentions to hearing the continual updates while he's canvassing the area. That's also referenced in Exhibit 2, the CAD sheet that was admitted. That CAD sheet details that Officer Doherty called off at 3:43 in the morning, meaning he was still hearing these dispatches.
What does called off mean?
When he arrived on scene, saw Mr. Privette on Ashland Street, he called off saying that there was a suspect that he was going to approach.
How do we know that that's what the CAD sheet means? I mean, I see an entry for him at that time, but I can't tell what it means, and there's no testimony I saw that illuminates it.
There is testimony, I believe, on...
I mean, I know he says he arrived at 3:43, but he doesn't say, I called in and said so, and that's what this particular entry on the CAD sheet means.
I believe transcript 20, he does use the words called off at that 3:43 time, showing that that's when he encountered the defendant and made this stop. And so again,
can we tell anything about from the CAD sheet about, well, it seems to me it doesn't really matter what we can tell from the CAD sheet based on what you've said about it here, because he testified that he heard that he was aware of the description that included the facial hair.
Correct. And on cross, he did state that the brief first description that was played on the dispatch, he did state that was in answering the question, that was the only description he had. He did answer affirmatively, but I would ask the court to take into the totality of the testimony that entered, as well as the exhibits that were entered, including the full turret that was entered and that CAD sheet.
Your sister says that we can't apply the collective knowledge doctrine without more findings here, particularly where Lieutenant Dwan says, I believe.
I don't think that would prohibit the court from using the collective knowledge doctrine here. There was no explicit findings by the judge that she did not credit either Officer Doherty or Sergeant Dwan during this. There was no explicit findings as to any supplemental dispatch that came out. The only finding was into that original, I believe it was footnote 4 of the judge's finding, was to that original broadcast, and I would stress the original part there. That was the only reference to any sort of discrepancy between the dispatches that were being received by the officers.
I don't know, and I don't think the record shows who it is that's talking on Channel 6. It seems obvious that there's a 911 dispatcher who's taking the information from the victim of the robbery, but we can't tell who's broadcasting the information out on Channel 6. It's a male voice. In order to apply the collective knowledge doctrine to what he says, does he have to be a sworn officer, or can a civilian's knowledge of the fact that the description includes a beard be imputed to the officers who are out in the field?
I don't believe the dispatch would have to be a sworn officer here. Again, I agree with the court that we aren't able to determine who that person is through the testimony and through the turret. However, I don't think that he not being a sworn officer would prohibit the collective knowledge doctrine.
Is there any case you have on that? I mean, because
Not
most
off-
of the cases I looked at regarding collective knowledge talk about imputing knowledge from one officer to another where they're jointly working on an investigation of some sort.
I don't have something offhand, but I would be happy to submit something to the court in regards to a non-sworn member of Boston Police's dispatch team, the 911 operators, being able to partake in the collective knowledge doctrine. Going forward, again, to this description part that I believe is being stressed, Officer Doherty did state on transcript page 20, that, matching the description, included the blue sweatshirt, which again, during cross was changed, the jeans, black male with a beard, and again, the only person on the street. That would bring me to the next factor here, that Mr. Privette was the only person on the street observed by not one, not two, but three officers as they were canvassing the area at 3:30 in the morning on a rainy night in August. I would argue that that goes strongly to reasonable suspicion that this was not a crowded area where they just happened to grab one person on the street. They grabbed the only person on the street, stopped him and talked to him, and eventually recovered the items in question. This is similar to, I would argue, the Evelyn case where there was extreme cold and there was the only person on the road going towards reasonable suspicion. Here, it's not extreme weather. However, it was dark and rainy enough that the officers needed to use the floodlights at the later bring back procedure. And again, no one on the road during this area that was canvassed, the surrounding area of Clam Point. The next factor I would argue would be the geographic proximity to location of the crime.
How much, just to go back to that prior point, how wide an area do officers have to canvass before the presence of only one person on the street contributes to reasonable suspicion? I mean, surely if they drove, directly from the area 11, is it? Or
11,
wherever, to the crime scene, and they only saw one person on the way, that's not a very powerful fact in favor of reasonable suspicion.
And that's precisely what did not happen here. Officer Doherty, being familiar with the area, both as an officer and someone who grew up in the area, canvassed this area knowing of this cut on the street going towards Morrissey Boulevard that matched the flight path. And he canvassed, I believe it was 4 or 5 streets. Lieutenant, again, then Sergeant Dwan, was on the main road of Morrissey Boulevard, went around several side streets in Clam Point. Again, did not see one person until coming across Mr. Privette on Ashland Street, the same time Officer Doherty did.
But there's a whole nother side of Morrissey Boulevard, or beyond that northbound side, that hasn't been looked at.
That was not looked at here. The canvas location was, through the testimony, limited to that Clam Point area, but I would argue that that would not limit. This was still an extensive search for any of the suspects. The officers did not simply respond to the location of the crime and try to find one person on that route. They were actively canvassing the area, consistent with the flight path that was on the dispatch coming across Mr. Privette. And I would argue that that flight path is, again, very relevant here for reasonable suspicion. This is very different than the Warren case, where there was a very, very limited description of a potential flight path that was then 25, 30 minutes later followed to discover 2 individuals that maybe came that way. In this case, the flight path was given through dispatch, fleeing towards the CVS on Morrissey Boulevard. That area was searched within 7 minutes and within, again, that a few blocks from the crime scene, and Mr. Privette was located there, matching physical descriptors as well. I would argue this is very different than the Warren case. And again, different than the Evelyn case, where the officers there, where reasonable suspicion was found, had a flight path, but accidentally went the wrong direction and still came across the suspect. Here, there was no mistaken path taken. They actively canvassed the area that would fall in that flight path. Another factor that I think goes to reasonable suspicion would be the geographic proximity. Again, this was mere blocks away, I think 700 feet from the Shell gas station that was robbed. Going towards case law here, Ducey, I believe, was approximately half a mile where reasonable suspicion was found, similar to Evelyn. And again, taking Warren into consideration, I don't believe that would be relevant here, where this is well within the geographic proximity of where this person could have gone in these 7 minutes. Of course, he may have been able to get into a car and get much further. With the flight path being dispatched on foot in the location of that CVS, I think this is very consistent with the flight path and the geographical proximity. Going further.
Is there any evidence about whether the CVS or the Chinese restaurant, for that matter, are open 24 hours or were open at the time of this incident?
I don't believe any testimony came in regards to the CVS being open or the Chinese restaurant being open. And I don't want to add personal facts to the area, but I don't believe any testimony came into their hours of operation.
So how is this case, how is the evidence here better than what was in Cheek?
So Cheek's description is much more limited than what was given here. In Cheek, the only descriptive piece of clothing was that 3/4 length down jacket that fit a very large portion of the population at that time.
Here it said hoodie and there was no hoodie.
It said hoodie, there was no hoodie, and I would argue that it also said much more physical descriptions that cannot be changed: height, race, build, the facial hair, and the age as well. My sister's arguing of 5'7" being so much different than 5'11". This is a robbery that took place in seconds with a firearm in the victim's face, as he's calling it to dispatch. I would argue that the difference between 5'7" and 5'11" is not so different as the difference between 4'11" and 6'3". That is not something that would jump out as a difference when the officers are looking at Mr. Privette. Same with the medium build. I don't think that can be just cast aside as being overly broad or overly vague. The age was an apt description. Mr. Privette, I believe, was 32 at the time, and the dispatch was 28 to 29. I would argue that is consistent with the description. And for Cheek, when the court was deciding that reasonable suspicion was insufficient, they actually listed missing factors that would have aided the reasonable suspicion, including height, weight, facial hair, and marking on face and clothing. Here, those factors are met. And similar to Warren, again, where there was a limited description, here they stated that the description was insufficient due to lack of any information about facial features, hairstyles, skin tone, height, weight, or other physical characteristics. Again, here, many of those are met. And going back to the factors, I would argue that the temporal proximity is extremely relevant here. As mentioned, there was about 6 to 7 minutes between the 911 call and the stop of Mr. Privette. Going to the case law, I believe the Ducey case is 12 minutes. The Evelyn case is 13 minutes. And again, this is 7 minutes within 700 feet of the stop with nobody else on the road.
Does it make sense? Is it a reasonable assumption that someone who just committed an armed robbery would not try to get further away from the scene than 700 feet in 7 minutes? 100 feet a minute is a very slow pace.
I agree that a normal pace would likely be faster than 100 feet per minute. I think that would take about an hour to walk a mile. And here with the intersecting streets, I don't think the true just measurement matters as much as the general proximity. Here, he is just a few blocks away from the gas station. And with Officer Doherty's knowledge about the area of Clam Point, knowing that there's that cutout in the fence that was very close by to where Mr. Privette was located, I think that's relevant as well. And for
but how does that help explain why he didn't get any further away than 700 feet if the defendant is the robber?
I don't know.
What was he doing in that time while he was walking along at 1 mile an hour, or was he hiding out for a while and then he decided, well, maybe I'll risk it, maybe I'll walk along the street? I mean,
exactly as the court pointed out, the clothing could have been changed. The outer garment that was described at first could have been taken off and placed inside a backpack that was picked up after the robbery was committed. That could have taken a few minutes before Mr. Privette was able to get on that flight path a little further down and be located by these officers. And lastly, for the 6 factors I mentioned, I would argue that the type of crime is extremely relevant here. This is a case where a firearm was not only seen by a 911 caller, but brandished into that 911 caller. I'd argue that public safety is a great issue here. Officer safety is a great issue here.
Doesn't Menaeus call that into serious question?
It does, but I would argue that the McCoy case would say that it is very relevant to the stop and frisk here. It states that that the type of crime can factor into the reasonable suspicion analysis. The fact that a firearm alone is used does not negate the need for reasonable and articulable facts, but it can be played into the analysis that goes into the weight of reasonable suspicion.
Remind me, does McCoy come after Menaeus?
I don't have the full cites in front of me. I would have
to. Actually, it doesn't. It's McCoy's 2013, Menaeus is 2017.
I would argue that it is just merely a factor. It's not something that the court needs to solely rely on, but I do think that it can be a part of the weight that is being discussed here. In regards to the type of crime, this is something that a firearm was not seen, it was brandished. And the defendant had, if it was the suspect was the defendant, had access to a firearm that the officers have to interpret as loaded, given it was used during an armed robbery with that firearm. Based on the totality here, I would argue that reasonable suspicion is in spades here. Taking away one of the factors does not negate it. There is ample reasonable suspicion here, and I would ask the court to affirm the denial of the motion to suppress.
All right, thank you both. Be watching your emails. It's very likely that you'll receive an order from this court about further briefing on the collective knowledge issue. So watch your email. We'll actually specify what we want if we choose to do that. Otherwise, we'll take the case under advisement. Thank you both. Excellent arguments, excellent briefs, and that's all.
Thank you.
All right, we are live and on the record.
Thank you. Good morning and welcome to the Massachusetts Appeals Court oral argument session for June 3, 2021. As you know, the argument is being held on Zoom and live streamed almost simultaneously on our YouTube channel. The panel for today is Justice Peter Sachs, Justice Sabita Singh, and myself, Greg Massing. We'll follow the same rules and customs as in the physical courtroom, except you may be seated if you prefer. Once we get going, the session clerk will display a countdown clock where the insignia is. As always, each side gets 15 minutes. There's no rebuttal. And only one advocate will speak at a time. We ask that you mute yourself when you're not speaking, but on the same time, please stay on the video so we can know you're there, and keep your reactions to a minimum because we can see that and it can be distracting. As always, we've read your briefs and we're familiar with the case, so you can get right into it. And if you see us looking away, it's because we do have your briefs on perhaps our tablets or our screens, so that's what we're looking at. We're not distracted. So with that, I'll call the case, which is 2020 P1011 Commonwealth versus MARIN-QUERALES, and we'll hear from Attorney Chayette.
Thank you very much, Justice Massing, and may it please the court, Kara Chayette for ADRIAN MARIN-QUERALES, who I'll just be referring to as Marin or Marin. I'd like to start with the constitutionality of the exit order and search based on the facts as found by the judge, and then turn briefly to the ineffectiveness claim and save 3 or 4 minutes to discuss the error in the jury charge and the prejudice that flowed therefrom. The Commonwealth's theory at the suppression hearing was that the trooper's observation of plastic bags, some with cut corners, in the cabin of the car and in the driver's side door pocket gave rise to reasonable suspicion that my client, Marin, was involved in drug trafficking. And the judge so found, most especially she found compelling, the observation that the trooper claimed to have made in the driver's side door pocket of said bags. On appeal, the court conducts an independent review or de novo review of the judge's application of constitutional principles to the facts as she found them. And that requires this court to hold, in a way that I have never seen held, that an item as ubiquitous as a plastic bag on its own, and that's all we had, is sufficient to give rise to reasonable suspicion or probable cause that somebody's involved in a crime.
Is that all we have? We have Mr. Fury, who's pretty clearly involved in dealing drugs, climb into this car after making 10 or so sales earlier that morning, or apparent sales. And plastic bags may be ubiquitous, but baggies, particularly some with cut corners lying around a car into which someone who's selling drugs climbs, I don't know how ubiquitous that is. Doesn't that at least create reasonable suspicion? I mean, if this were a traffic stop, reasonable suspicion would be enough to issue an exit order under Torres Pagan and many other cases. This isn't a traffic stop. This is a stop essentially to probably arrest Fury and investigate whatever else is going on there. Why isn't there reasonable suspicion at least to issue an exit order?
But the only articulable, individualized fact concerning Marin, I mean, my guy could have been an Uber driver. a friend who picked him up. It's one thing if add a fact that is, oh, sorry.
No.
Oh, add a fact if Fury had gotten in the car and from the window, Fury had engaged in a transaction. Now we've got drug dealing happening in the car or anything else. But plastic bags, I actually would point the court to Fernandez with an S. It's attached to the back of the
That
briefing.
was
You know it.
Yes, that's one cut corner of one baggie. This is multiple baggies in multiple places around the passenger compartment.
I understand that, but also in Fernandez, there were also multiple cell phones which were suspected of being evidence of drug dealing. I understand that, but I still think there's got to be, we don't know anything. If you take the totality of the circumstances, a drug dealer who is doing nothing to conceal his illicit activities, broad daylight, under surveillance for hours and hours, either unconcerned about or indifferent to the fact that he's under surveillance for all of those hours, gets in the car and drives half a mile to a Dunkin' Donuts. The fact that some of the bags might have been cut corner, might have been plastic, a lot of them were just regular bags. Of course, we don't have any collection of them. We don't have any evidence that they exist, which actually, let's put it this way, if the court is convinced that those bags really matter, then I'm getting into my Sixth Amendment argument about trial counsel's failure to prosecute his two theories about the bags that were winnable, what standard you test that by. But I don't think that the bags alone, and I haven't found a case yet that says the baggies alone, without furtive movement, something else observed. And again, I think about the Uber driver, that how is this, you've got a driver with some plastic bags floating around.
Counsel, we can't look at the driver with the plastic bags in isolation from Fury. That is part of the mix.
But is the fact that drug dealers engage in ordinary activities, they take cabs, they take Ubers, they have friends, is it the case that anyone who interacts with a brazen drug dealer is sort of, it's like Pigpen from Snoopy, that he's got this sort of air of criminality that infects and touches every person that he comes into contact with? I think there's got to be more. And Fernandez with a Z, which the Commonwealth relies on and that the motion judge did as well, is sort of similar. But in that case, the car was the site. The court considered it like the store out of which drugs were being dealt. And therefore, the passenger who had nothing on her, she hadn't touched drugs, she hadn't touched money, was susceptible to reasonable suspicion because, again, the car's the site of the crime. Here, there's no transaction happening in the car. And bear in mind, of course, the fact that the car didn't even belong to Marin, it belonged to somebody else.
So a family member with whom he lived.
Yes, but no evidence at any point. First of all, again, drifting into
and it's not Fury's car. It's not a car that's under the regular control of Fury. That seems pretty clear. It's under your client's control. I
understand that, but the best cases seem to say that an item that's ubiquitous, that can be used for licit and illicit purposes without more. And if you're going to use the proximity to a criminal as the plus factor, I think that's a real problem. But I would like to turn, if we sort of move from that, to the Commonwealth's argument in its brief that the other basis for finding this lawful, that the theory that that the drugs were found pursuant to a lawful search incident to Fury's arrest. I know that in my reply brief, I focused on that argument in Gantt about the protective sweep to prevent the destruction of evidence within the occupant's sort of grabbing area. And I argued about why that you couldn't affirm on those grounds.
Is Gantt really limited to, Gantt talks about protective sweep to make sure there are no weapons in reach. But does Gantt limit search incident to arrest for evidence to the sort of wingspan of the defendant?
Well, there's that.
I didn't see that limit.
Well, so there's that other, I think that the best argument that the Commonwealth could make is that it falls within that it was reasonable to believe that that evidence of the crime for which Fury was being arrested would be found in the car. And so I've actually spent a lot of time in the last couple of days thinking about that, because I didn't include that particular argument in my reply brief. And it looks to me like there's a lot of debate about whether that language is a per se sort of a that it's a categorical rule that some crimes are unlikely to yield evidence in the location, other crimes are very likely to yield evidence. Drug dealers tend to conceal items, therefore if it's a suspected drug dealer, that he's likely to have it in. Or other courts have said there's always a reasonableness inquiry with Fourth Amendment cases. And since Gantt was sort of pulling back on the breadth of the construction of Belton, don't we have to think about reasonable to believe from the totality of the circumstances? And I found one Ohio intermediate case that really lays out both of these arguments, because I didn't find any discussion of this in Massachusetts. However, in Starkweather, Commonwealth v. Starkweather, 79 Mass. App. 791, this court did apply a totality of the circumstances understanding of the reasonable to believe language out of Gantt. And in that case, a woman was raped in a Jeep. The cops find the defendant moving items from the Jeep into his pickup. And the justification for the search of the Jeep, which uncovered handcuffs, was that it was reasonable to believe, given that the rape occurred in this Jeep, it was sort of, there was a totality of the evidence analysis conducted. And the totality of the evidence here, again, yes, this guy's brazen, bright daylight, sunny day, not a high crime area. A car comes along that the police know nothing about. And he gets out of the car. And in fact, he does have 10 bags of saleable drugs literally hanging out of his bag, out of his pocket. And so the suspicion that a drug dealer is going to have evidence of the crime, well, it was right there hanging out of his bag, out of his pocket. The notion that from there we get into the car, I think is really a stretch too far, and ends up being about proximity to a drug dealer. I'm happy to.
I was a little confused about the facts. And you make an argument about the inventory versus the evidence log, and how counsel dealt with that. Could you explain that a little?
So on the ineffectiveness claim, trial counsel had two theories. One was the improbability of the observation of the driver's side door pocket preceding the exit order. The other was this theory that those plastic bags that the trooper claimed to have observed that were so critical to the Commonwealth theory and the judge's findings, that they simply didn't exist. And so in the arrest documents and the evidence log, it shows that there's exactly one item that was logged into evidence: the drugs themselves. That
I don't see anything constituting anything entitled evidence log. I've looked at the DOJ. This is at Appendix 237, I guess, through 239. I don't see anything that's purports to be a complete list of evidence seen, let alone evidence seized. So plus the Appendix 239 is pretty much illegible, unfortunately.
Well, so if you look at in the record appendix 255 to 256, it describes Exhibit 1.
Oh, I'm sorry. I was using the printed page numbers, not the ones in the right ones. Yeah. So I'm looking at RA 256. Yeah.
And so it says that Exhibit 1 is the gum container of drugs. It talks about in the note in the investigatory report that all drug and non-drug evidence was logged into evidence. And then it identifies Exhibit 1 as the only thing that was, and I'll get to the same, make sure I'm looking at the same page, 255.
Yeah, I've got RA 256, so.
And so it talks at the Exhibit 1 was seized, processed, logged, and stored pursuant to state police policy. And then the next page, which is fairly illegible, but if you look at the remarks, it repeats, if you look really closely, that Exhibit 1 was logged in. And so there are documents in the record that show that there's exactly one thing that was collected. And remember, the trooper said, I didn't write a single thing down, no photos, no nothing to refresh his
You're saying you should
recollection.
have impeached him with the evidence log.
Instead, he used the inventory log, which the trooper had an excellent explanation for why it was blank. There were no valuables found. And he offered the inventory policy, which seems to be to protect my personal valuables from being lost or damaged or stolen, and protects the police from false claims of loss of private valuables. But he had this other, so that he gave the trooper an excellent way to explain that. And then the improbability of the observation, I think I laid that out enough in the brief. I see my time's clicking down. Unless there are more questions on this, I did just want to touch on the trial error, and particularly the improper jury charge, if I could. So the judge said about 6 times that, well, that there's a single element that the Commonwealth had to prove, because there was a stipulation that the quantity of drugs recovered was sufficient to prove distribution and not personal use. The only question was whether my client constructively possessed the drugs in that console. And the Commonwealth had to prove both knowledge that the drugs were there and an intent to exercise dominion and control over those drugs. And the judge repeatedly said, it's knowledge or intent, it's knowledge or intent, knowledge in the alternative to intent. And he said explicitly, one of the things the government has to prove beyond a reasonable doubt is that the defendant knew the drugs were there as an alternative to intent to exercise dominion and control. Yes, he then gave a correct instruction, but he did not notify the jury that the last instruction was the correct one. And I know my time has expired. If I could take 10 seconds to just highlight that where the trooper talked about Mexican drug labs, and we have a brown defendant sitting in the dock, and where there was no impeachment of the trooper with respect to the plastic bags, all the jury had to find was that he knew the drugs were in the car. And that was sufficient to convict. I just don't think that Justice Massing,
Oh no, I've got dust flying here.
that there was just the Commonwealth's burden was lowered, and because of the other unobjected to trial errors, the missed opportunities at every stage, that it created this substantial risk of a miscarriage of justice. And I just don't see how it can be upheld.
Okay, thank you.
Thank you.
Seeing no other questions, we'll hear from the Commonwealth.
Good morning, Your Honors. May it please the court, Donna Marie Heron, Assistant District Attorney representing the Commonwealth. As an initial matter, I do want to point out I have an error in my brief in the factual recitation on page 14, and I apologize for that. In my brief, I state that when the trooper pulls Fury out of the car, he observes the big plastic bag with drugs protruding out of it in his back pocket. He observed it in his front right pocket. So I apologize for the error in my brief, and I think it is an important distinction, because he clearly, in plain view, when he looks in the car, sees the bag of drugs on Fury's lap. That way lays into my point that the motion judge here, Judge Spring, properly denied the defendant's motion to suppress based on the testimony she found credible, that the troopers lawfully stopped the defendant's vehicle in order to arrest Fury, whom they observed engaged in numerous hand-to-hand drug transactions, and then upon further observations of the interior of the vehicle, had probable cause to search the vehicle. I think the Judge Spring was relying on the Fernandez case and relying on the Kennedy and Freeman case was well warranted in finding that there would be probable cause that drugs would be in the car because Fury, who they observed engaging in numerous hand-to-hand drug transactions, and indeed they confirmed that it was heroin/fentanyl when they stopped that one motor vehicle and drug tested, did a field test on the drugs that they seized from that person who they stopped, that he had drugs on his person. And therefore, when he makes one last hand-to-hand drug transaction and then jumps into the defendant's vehicle, there's probable cause to believe that there's drugs in the defendant's vehicle because
Even
Fury
without
is now
having
in the
seen
defendant's
the-
vehicle. I'm sorry,
even without having seen the plastic bags in the vehicle yet, you
Yes,
say when you say the minute that Fury gets into the car, there's probable cause to think there's additional drugs in the car?
because Fury's in the car and we know there's drugs on Fury.
Okay, but are you saying that there's probable cause to think there are drugs in the car that aren't on Fury?
No, I think that Fury's in the car, so therefore there's drugs in the car. So that's probable cause to stop the car. And then once the trooper arrives at the car.
Actually, I want to ask you, even if there's, setting aside your supposition that he's still got drugs on him, you know, maybe he hasn't sold out, but they've observed him selling drugs, and he gets in a car. Can they just stop the car on
Yes.
that observations of him selling drugs?
Yes, Your Honor. Particularly this is, as was made stressed by the motion judge and stressed by the trooper at the hearing. This was the only car in this whole time period that he gets into, and that takes off. And I think that factor plus the numerous observations of hand-to-hand drug transaction gives them probable cause, at least reasonable suspicion, but I would suggest probable cause to stop that vehicle. And
So
then
even if it is an Uber, they could pull
even if it
over.
was an Uber, yes, Your Honor, the fact that Fury's in there, they now have probable cause to arrest Fury. So they have probable cause to stop the vehicle in order to arrest Fury.
Okay.
And then after that, once the trooper goes up to the passenger door and makes further observations of the bags of drugs protruding from Fury's lap, and then the numerous drug plastic baggies, which the judge found was consistent with the baggies that Fury had and the ones that he'd been using to sell the drugs, gave probable cause to search the vehicle. I would also,
I mean, there was no ability to determine that the baggies in the car were consistent with what Fury was selling until after they'd been seized, was there?
no, the judge found in her findings that they were consistent with the baggies that Fury had been selling based on the fact that they had pulled over that driver ahead of time and
Sure,
seized the drugs
but
from
when the
him.
police are looking in the tally is looking in the window and he sees the plastic baggies on the floor or in the pocket, perhaps, of the driver's side door, can he see, oh, these baggies are consistent with what Fury's been selling?
It is what the judge found in her findings of facts on, I'm sorry, I'll give you the exact paragraph in which she finds that. I apologize, Your Honor, give me one
Yeah,
second.
well, we can
Okay, she
locate
did
that.
specifically find that. I just think it's similar baggies. Could you say they're exact same baggies? No, she can't, but she finds it similarly packaged or similar baggies are found in throughout the car that the judge find that the trooper testified was clean, was rather clean other than these baggies being around and was in the front door pocket. I would also suggest, even, and I recognize this was not argued below, but I believe on these facts in this record, this court
Before you go,
can
the baggies, these are empty baggies. They don't
Yes,
have,
empty baggies. There's no drugs in these baggies. And I would suggest to go the other argument, the search incident to arrest, which I know was not argued below, but I believe can be determined based on the record and the findings of this of the judge, that there was search incident to arrest would have also yielded the drugs found in the center console. And I would suggest this court look at the Young case, which I cite in my brief, which is 78 Mass Appeals Court 548 into 2011, and they actually addressed the Gant case in that decision, and it's strikingly similar to our case. In that case, Your Honors, the officer observes a motor vehicle infraction and stops the car, and the driver of that car has a bag of drugs protruding from his front pocket. The court found that that was probable cause to take the driver out. And then they said, and it was probable cause to search the car. And in order to effectuate the search, they could issue exit orders for both the two passengers in order to do a search incident to arrest. And that the court affirmed the exit orders based on that ruling. And then it was during the search, the facts later on in the case, that passenger who was the defendant in the case had a gun. But the point is, this court found that once they saw drugs protruding from the driver's front pocket, they could arrest him and search incident to arrest, and they could order the passengers out of the car in order to effectuate that search incident to arrest. And then I would suggest all the case law says based on a search incident to arrest, you can search everything within the reach of the person who you've arrested, which clearly the center console, which is right next to where Fury was sitting, was within his reach. So I based on search incident to arrest, this court could also affirm the judge's order affirming the motion to suppress. And I would ask this court to affirm that order. If there's no further questions on that, I will turn to the ineffective assistance claim, which I suggest is belied by the record. This trial counsel, based on all his filings, rigorously argued against, filed a motion to suppress, rigorously argued the motion below, and in his motion to reconsider, and also in his 211(3) petition. And I think the fact that, so the argument that he didn't properly argue this, I think is belied by the record, because he made all the arguments he could below, arguing that the trooper wasn't credible when he said he could observe the plastic baggies, then making the argument that there was no justification for ordering the defendant out of the car, that there was no justification for searching the car. All these arguments were made below, and I would suggest were adequately made below. So I think the record belies any claim that there was ineffective assistance of counsel, except if there's any further questions on that, or.
Well, so what's the defense at trial? He concedes, distribution. What's the defense?
The defense at trial was that he was just driving this car. They were stopped at a Dunkin' Donuts / liquor parking lot, that there was no drugs found on the defendant, that there was no DNA on the baggies on the subject console, that there was no fingerprint. So his defense at trial was that I was just driving. I had nothing to do with this. There's no evidence tying me to the drugs. So therefore I am not guilty of it. That was his defense at trial, which I think is pretty much the only defense he could go for. So I think that was also not ineffective assistance to pursue that at trial.
How about not asking for somebody to be seated in the car so the judge could make a judgment of whether you really could see the baggies that way?
I would suggest, at least for putting the defendant in the car, counsel made a manifestly reasonable decision based on what he knew about the court proceedings and the fact that a defendant who's in custody is not likely going to be allowed to walk across the street and sit in a car outside the courthouse. Regarding having anyone other, I would suggest even if this court were to find that it was manifestly unreasonable, it didn't deprive the defendant of an otherwise substantial ground of defense. And I would suggest if you actually look at the picture submitted by the defendant in record page 250 to 252, and during the cross-examination of Attorney Bosk at the motion for new trial, he had conceded you can still see the tops of the baggies even with someone sitting in there in some of those pictures. So I would suggest, based on the record, including Judge Springs finding that he could see it, and the record appendix, the pictures provided by the defendant, you can still clearly see the plastic baggies, even with someone sitting there in the front seat pocket. Moreover, the judge found that there's plastic baggies around the car as well. So I would suggest, even if this court were to find that defense counsel was ineffective for failing to put someone in the driver's side seat, it didn't deprive the defendant of an otherwise substantial ground of defense or prejudice the defendant.
Can I ask about the motion judges, the second judge who ruled on the motion of new trial declined to reach the claim of ineffective assistance with respect to the motion to suppress?
Yes.
I don't understand that ruling. Do you? And you contend that that was proper?
Yes, it was, because the request, so from the beginning, the Commonwealth's position was if she was to challenge Judge Spring's ruling, and we still have Judge Spring sitting here, we should go back in front of Judge Spring and argue this. That was objected to. And so therefore Judge Pellegrini, recognizing that, and even asked at the motion for new trial, well, isn't that the way it should go? The answer was that it's harder on appeal to get something reversed, and it's easier to do it below. So she wanted to do it below, which allowed to do under motion for new trial. Yes, you can. I would suggest that what she was doing was a very late motion for reconsideration of the denial of the motion to suppress.
Well, it doesn't seem like it doesn't seem like reconsideration. It seems like a new theory. I mean, it's ineffective assistance of counsel on the original motion, which is not something that you can assert in the original motion.
No, but you could have done a motion to reconsider, or her whole argument, essentially, a defendant's whole argument was that the trooper was clearly lying, that the trooper is a liar, that she should not have credited, that was heavily argued below, that she should not have credited his testimony. And I suggest to you, if anything, that is for to go in front of Judge Spring, or more appropriately should be as we are today here at the appeals court, and that this was an untimely motion to reconsider, as Judge Pellegrini, for that reason, properly declined to decide it, because she was essentially asking him to overrule Judge Spring's factual findings and say that Judge Spring was wrong when she credited the trooper's testimony.
So are you saying that we can't review whether there was ineffective assistance at the motion stage? Because
I think you can, yes, you can. This court, that would be the appropriate place for this court to review that, Your Honor. And I would suggest Judge Pellegrini.
Wait, I'm sorry. I want to make sure I understand. If Judge Pellegrini wouldn't review the ineffective assistance claim with respect to the motion to suppress ruled upon by Judge Spring, then we should rule on it in the first instance?
Yes, because you have Attorney Bosca's testimony regarding
yes, but
that.
so did Judge Pellegrini.
Judge Pellegrini addressed whether he did address whether he found Bosca was ineffective, but he was not, he made it clear, which is, I would suggest you read, if you read the motion for new trial transcript, the defendant's claim was that the trooper was lying and that Judge Spring should not have credited his testimony. And I think Judge Pellegrini correctly determined that he was not in the position to overrule another judge's factual findings, and then that should be determined at this
But
court.
how was it? I don't. Sorry, Judge Singh, go ahead.
Yeah, it seems there's a mix-up of what's being reviewed. The motion judge's determination or the ineffective assistance of counsel at the motion hearing. I mean, they're sort of. Are you saying that I'm sorry, there's so many motions. There's the motion to suppress, the motion for new trial.
Yeah, there was a lot of motions.
But the judge on the motion for new trial was not being asked to rule on the motion to suppress judge's ruling.
I believe
right?
I think there's two parts to the claim raised below. One was definitely ineffective assistance of counsel for failing to put the defendant or someone else in the car seat. But I think another huge part of the motion was that Judge Spring was wrong in crediting the trooper's testimony. So I believe that Judge Pellegrini correctly said, I am not going to rule that the judge should not have credited the testimony. Now, if this court finds that
Of course,
Judge
but
Pellegrini,
that's not an ineffective assistance claim. We're asking about the ineffective assistance claim, which is did counsel at the motion to suppress do, did he meet the Safarian standard? I don't see why Judge Pellegrini couldn't have decided that without calling into question Judge Spring's factual findings.
well, if this court concludes that, I would suggest that you can, again, the record is complete for you to decide whether that, as I argued, does not, but it's for you to decide whether that qualifies as you're as in a better position as Judge Pellegrini is whether that qualified for ineffective assistance of counsel, given that you have all the exhibits that were admitted below and you have the testimony that was taken at the hearing. So even if this court were to conclude that Judge Pellegrini should have ruled on the motion, you're in a same position as him to rule on the ineffective assistance of counsel claim. So if anything, the Commonwealth will lose the abuse of discretion part and we'll just go slowly on whether the two-part analysis of whether it was ineffectiveness and whether it created deprive the defendant of an otherwise substantial ground of defense of prejudiced him. And as for the arguments I raised earlier, I argue it did not. If there's no further questions, the Commonwealth will rest on its brief.
Seeing none, thank you both. Difficult case, and we'll take it under advisement.
All right, we are live and on the record.
Thank you. Good morning, Council, and welcome to the Massachusetts Appeals Court oral argument session for June 3, 2021. As you know, we're conducting the argument on Zoom, and at the same time, it is being live streamed on the Appeals Court YouTube channel. The panel for today is Justice Peter Sachs, Justice Sabita Singh, and myself, Greg Massing. We'll follow the same rules and customs as in the physical courtroom, except you're free to remain seated if you prefer. Once we get going, the session clerk will display a countdown block where the court insignia is. Each side gets 15 minutes, no rebuttal. You're welcome to use all your time, but there's no penalty for finishing early. We ask that, of course, that only one advocate will speak at a time. And we ask you to mute yourself when you're not speaking, but to remain on the screen so we can know you're still here. And at the same time, though, since we can see you, please keep reactions to a minimum because that can be distracting. As always, we've read your briefs. We're familiar with the case, so you can just start right into your arguments. And in fact, we have your briefs and record materials on our computer, other screens, on our tablets. So if you see us looking away, it's not that we're not paying attention to you, it's that we're looking at record materials. With that, I'll call this case, which is 2020 P1030, co-trustees of the COMAR Real Estate Trust versus City of Somerville. And the appellant is the city, Attorney Shapiro.
Good morning, Your Honor. David Shapiro for the City of Somerville. This is a relatively straightforward one-issue argument. It involves the sufficiency of an affidavit filed by the plaintiff in connection with a non-conforming use. Very briefly, it's a 2-year period in which the applicant must do something to avoid being a discontinuance. And the issue is this affidavit sufficient or not? Now, the plaintiff did file an affidavit stating essentially that the project manager spoke with somebody, didn't identify who it was.
Well, the person sitting at the desk, right, in the building inspector's office, the person at the front desk.
Right.
Right.
Right. It was somebody who certainly worked in the building official's office. We have no dispute with that, assuming that it happened. But it didn't identify that person's title. It didn't identify the person's description. It didn't identify something for which I could reasonably have been expected to know who it was to even inquire of. As to
how many people work in that department?
I'm going to estimate around 20, 25-ish. You have building inspector, you got plumbing inspector, electrical inspectors. We have a paralegal. We have various staff members, administrative assistants. So you have roughly 25 people, many of which no longer work with the city. And, you know, I mean, to me, it's the analogy I come up with is if somebody walks into the police department and says, you know, there was a person in the police department who worked for this police department who told me not to worry about the ticket. Would that be sufficient? And I don't think it would be. The case I've cited is the Perez case, where it doesn't need to spell out every detail, certainly an affidavit, but certainly enough for me to know who to inquire of. It's conceivable in this particular case that the affidavit was, that the person that he spoke with was somebody at the front desk who would not even have been a building inspector.
Who has the burden of proof on this issue? If it went to trial?
If it went to trial, the burden would be, I believe, on Mr. Madden, on the plaintiff, to show that it actually happened. And that's why, to me, this is a factual issue. You know, at trial, I'd be able to cross-examine who, you know, do you have any more information about who they spoke with? My position is basically the
you could have deposed the affiant. Maybe you did depose the affiant. I can't remember.
I did not, and the reason I did not was because of my discussions with Mr. Madden. You know, the indication was that there's nothing else, and that's what he has.
Okay, so if he says this I mean, why isn't that enough? There's no dispute. If you don't have anything to dispute it with, and you're not going to, you've apparently agreed you can't get anything out of him on cross because you decided not to depose him.
Well, no, what I can get out of him on cross is sort of the information that he doesn't have. And then it'll be up to the judge to decide whether it did or didn't happen or not. In other words, I could cross a person at trial and say, well, you don't know who you spoke with. You don't know when it was. You don't know what the person's title was. These types of things I could cross-examine that person on a trial. I didn't bother taking the deposition because I don't think I would have learned anything other than those, prima facie facts that he had. It's up to,
in disputing, in encountering this affidavit, could you not have submitted something saying, we've interviewed everyone in the department, something indicating that we have no knowledge. Instead, there was I think all that was submitted was something to the effect of, we have no records. And
right.
There wouldn't necessarily be a record of a conversation.
Right, and I could have done that. Reality is, in this particular case, at least 2 of the employees, I believe, went out on bad terms. I wasn't going to contact them. I didn't think I have to. And well, at least one of the persons actually was deceased. I actually did speak with several of the staff members, and they all said that they had no memory of it happening.
Yeah. Although this is all
that wasn't sufficient.
Although this is all outside of the record.
Right. But that wouldn't have been sufficient, I don't think, for me to even say that, because it wouldn't have countered the point. So I guess my position is,
what about just the practice of the department where we don't turn people away, or something to say that there was some way, some systematic way that the department dealt with this issue, and because it seems to me, if the other party has the burden, and there's no system in place of saying, what was done, or these people came to the office, then they'll never be able to make their claim, right?
well, I think in this case, if they had sent a letter saying, I'm trying to file this document, the reality is, at least in my world, there's usually documentation of it.
But there was some documentation, wasn't there? Wasn't there documentation in the form of, there were plans that were dated around the time?
Right. He ultimately filed it after the 2-year period had expired. So certainly, there was certainly a filing that was made after the expiration of the 2-year period.
But the plans were dated before the expiration.
They were dated before the expiration, but there wasn't any documentation that was filed with the city until after the 2-year period. So the issue is, during that 2-year period, does anything happen? And it kind of refers back to my point that there really wasn't a foundation for which I was required to do a counter affidavit. And if I did a counter affidavit, I don't think it would have even necessarily even rebutted what he said in the affidavit, unless I found someone to say specifically, unless I got everybody who had worked there and they all said it didn't happen. Nothing else to me would have been sufficient to create a decent factual issue to contradict what the affiant said had happened.
On the moratorium thing, I mean, is it plausible that in the month of January 2010, that people in the building department would have said, we're not taking anything right now, there's a moratorium?
Is it possible that they would have been mistaken?
No. I mean, was that not the case? But it wasn't. They were accepting things during that month.
The understanding of the staff was that there was a moratorium in place. The staff who spoke with the affiant. So that staff thought there was a moratorium in place, but there actually wasn't, according to So theoretically, if the affiant had spoken with somebody who actually knew what was happening and knew all the details and facts, that affiant would then have spoken with maybe the department head or somebody who knew there wasn't a moratorium and said, well, yep, you can file this right now.
Is there evidence that the staff believed the moratorium was in place beyond the affidavit filed by the filer of the application?
No.
Okay. May I ask, what's the practical significance of this? If we were to affirm the decision in COMAR's favor, the trustees' favor, Ocean State Job Lot is no longer a proposed tenant. I assume their building permit application has lapsed or it was withdrawn or something. Why hasn't Star Market's use now been discontinued for more than 2 years? Or has there been something going on in the meantime that's kept alive that use so that it would still be protected even if, in light of the change?
So the practical significance is that if the use is deemed to be protected under 48 Section 6, then there's more flexibility for the property owner to use his property as he deems fit.
Sure. But my question is, what would have protected it in these intervening years, given that Ocean State Job Lot was no longer a proposed tenant?
Oh, because I think this litigation would have protected it. In other words, because the right, I think it's the litigation itself would have protected it because you know, it's still ongoing. It would be unfair for the city to say, well, now you've lost it because it's been, you know, in court for the last 10 years.
So if we affirm that, then you wait for the next the landlord to come up with another applicant, and then you assess their use under the 2010 zoning statute under the powers test.
Right. If the court affirms, then we believe that the powers test would apply, and you analyze it. You look at the nature and purpose of the supermarket, and you compare the proposed use to that.
Right. I mean, you believe that, and that's what the judge said. Apparently, that's what the panel of this court also said.
Right. Exactly. Right. Right. Yeah. So you look at the supermarket and you compare the supermarket to what's being proposed, as opposed to some broad retail category. Right.
Can I ask you, when this was submitted to the judge on cross motions for summary judgment, is it accurate to say that it was submitted indicating that it could be resolved on summary judgment, meaning that there is no factual dispute?
Not quite. I was going to bring up that point. I'm glad you asked that question, Winner. If you look at Exhibit 3 in the appendices, and I'll read it, it's only 4 lines. It's the amended joint statement of agreed material facts. And it essentially states that the joint statement of agreed material facts previously submitted in accordance with the court's order of April 19, 2018 is amended by substituting the following agreed facts. And here's the key point. Each party will submit such additional facts as they may appear from depositions, interrogatory answers, and affidavits as support of its motion. So essentially, we had agreed to facts, probably 90% of them were agreed. Roughly 10% were not agreed. And that's where the plaintiff did submit the affidavit of Mr. Parker.
So where is that Exhibit 3 and which volume of the record appendix?
I believe it's in the first volume. It's the title is Amended Joint Statement of Agreed Material Facts and Exhibits on Cross Motions for Summary Judgment.
Oh, I see. And on the first page of it. All right.
Yeah, that's the title.
Record appendix 2, page 46. Got it.
Yes. Yeah, that's the title of it. So unless there are any further questions, I think the crux of our argument is that there's an insufficient legal foundation for the affidavit. The best case I have is the Perez case in the brief, as well as the notation in Mass Rules of Civil Procedure Rule 56 in the reporter's notes, which essentially says that I don't have to do a counter affidavit, even though certainly the cases usually indicate it's required, but there is an exception where I don't think there's a sufficient legal foundation for what is in the affidavit of the proponent. Unless there's any further questions, I will rest my brief.
Seeing none, thank you.
Thank you.
We'll hear from Attorney Madden.
Thank you, Justice Massey. I was just trying to unmute my microphone here. Good morning, members of the panel. It's a pleasure to be back in court, even if it's only virtual. I'd like to first address the question that you asked, Justice Massing, which is whether the use must be assessed under the powers test and under the 2010 statute. I believe that because it is a protected non-conforming use, it would revert to the earlier statute and not be assessable under the new statute. And I'll get back to this point a little bit later, but obviously the new statute cannot affect a pre-existing non-conforming use because it is protected against the new statute.
I'm sorry, when you refer to the new one and the old one, which ones, can you give us a date, what you just did?
The 2010 statute is the new statute, which became effective, I believe, on January 11th, approximately 7 days after the building permit application was finally filed with the city and accepted. So it would have been January 11th, 2010. The earlier statute was the the earlier ordinance, not statute,
right,
was the 1960 ordinance. And if I refer to these as statutes, my apology.
You didn't file a cross appeal, right?
Correct.
So I mean, the court's determination that the 2010 zoning SZO applies and that you apply powers to that, that's the law of the case. That's not subject to appeal.
Oh, I don't think that the court made that ruling at all. The land court judge did not say which ordinance applies. She simply said that she was adopting the previous ruling by the appeals court in the first version of this case, that the so-called powers test would apply. And I think if the judge even remotely would have suggested that the 2010 ordinance applies, it's clearly an erroneous statement of law. So that if we were to go to the city and say we have a new tenant and we want you to assess whether this new offer or new occupancy is compatible with the pre-existing use, and you must apply the powers test, then the powers test cannot look to the 2010 ordinance. I mean, it would just simply be illogical.
But if the judge said that, I think you're stuck with it.
I don't think that the judge remotely came close to that,
okay, well,
because my memory of her opinion, Justice Massey,
you do ask us in your prayer for relief that we issue a clarifying statement, or to some extent. But that's since you didn't appeal anything below, I mean, there's nothing for us. I mean, the only issue before us that I can see is whether the affidavit established that Ocean State filed an application.
Absolutely correct, Justice Massey. That is the only point on appeal. The point that I was making about a clarifying statement is that I wondered why the city is even appealing. How exactly are they aggrieved here? They seem to be arguing in the alternative. Number one, that this affidavit was insufficient, and then saying, but even so, the powers test applies. All that the trial judge did in the land court was say, the appeals court in opinion 1 stated that the powers test is what applies, and therefore I don't need to reach that issue. So that's why I'm saying that she couldn't have said that she was assessing it under the 2010 ordinance. In fact, she didn't even address the 2010 ordinance in her opinion. What I'm getting at is that the city has a new ordinance that essentially says you can have 1,500 square feet of use as a matter of right, but that same use, if it has 5,000 or 10,000 square feet, requires a special permit. So if I were to divide this building into, let's say 15 retail spaces of 1,500 square feet each, selling exactly the different kinds of things that a supermarket sells, those would be permitted, but if I combine them all, then it would not be permitted unless I got a special permit. And what I'm saying is that the powers test cannot be a test that allows the city to say, even though we allowed a supermarket, retail, or pharmacy use back in 1960, and there was no separation among them, if you switch from one to the other, you have somehow invoked the powers test because you're no longer a protected use. And I'm asking this court, in the interest of common sense, to issue such a clarification. Now, how do you get there legally? So the issue is, because your review is de novo, You can affirm on any ground that's in the record. And you're certainly free, if you are able to affirm on any ground, to clarify on any ground. And that's really what I'm getting at.
Can I ask you about the affidavits?
Yes.
Actually, and it's not the, was there evidence in the summary judgment record that that employees of the building inspector's office believed in January of 2010 that there was a moratorium and they weren't accepting applications? Or did Mr. Parker happen to come across the one uninformed member of the staff?
Okay. First of all, there is evidence, I believe, but let me say that I don't think that it is permissible on summary judgment to make an inference that there is one uninformed building department employee. Because even though as the losing party or the non-moving party for this particular aspect of my motion, the city is entitled to all inferences to be drawn in its favor. It is not entitled to an unreasonable inference. And it would be an unreasonable inference to say that there is one uninformed building department employee. So now let's go to the evidence in the record. We have evidence, number one, that the city actually submitted a request for extension of the moratorium, but eventually it turns out it simply wasn't acted upon. So officially, the city was looking to have the moratorium extended well past January. The second thing is that you have the affidavit of Mr. Cohen and also the affidavit of Mr. Parker, who says that when they were at a meeting with the people from the city of Somerville, the official in charge of zoning, Monica Lamboy, stated that the city would not allow Ocean State Job Lot to do any of its renovations and the build out it proposed because of the moratorium. And in fact, she said this twice. Mr. Parker affirms this, Mr. Cohen affirms this in his affidavit. So
is there an affidavit or any evidence from Monica Lamboy to the contrary?
No, the city, as the city points out in its reply brief, they simply chose to ignore this issue. And case law we've cited says you can't do that. And that's what the land court judge said. You simply cannot ignore an affidavit. And I think the important point over here, if I may, is that what Mr. Parker's affidavit needs to establish is that he attempted to file a completed building application. It's not really important what reason the city department employee gave, although that reason was relevant to the secondary issue of whether the moratorium affected the 2-year period. The trial judge simply did not reach that issue because she was able to resolve the case by determining that the city had simply not presented any evidence to counter the undisputed affidavits of Mr. Parker and Mr. Cohen.
What do you say about the point that the affidavits themselves were insufficiently detailed?
Okay, so Justice Singh, before I move to that, I also want to address your question that you asked Mr. Shapiro, which is, was it agreed that there were no facts in dispute? And Mr. Shapiro's answer is that the parties sort of reserved the right to supplement the record where necessary. And he agrees that the plaintiff did provide such an affidavit. And obviously, to the extent that there was any dispute, our affidavit took care of that issue. And it is axiomatic that a party cannot move for summary judgment unless it represents that there are no facts in dispute. So here we did have, as you noted, cross motions for summary judgment, which is completely at odds, with all respect, to Mr. Shapiro's statement. Now,
well, you could move for summary judgment saying that the other side's facts might be in dispute but aren't material.
Oh, absolutely, but that's really not the argument they made. What the argument they made was that there were credibility problems with Mr. Parker's affidavit, and now in their reply brief they say all we did was raise the legal sufficiency of the issue. So now let's look at that affidavit. I think there are two interesting points. Number one, Mr. Parker gave a very discrete time frame, middle of January to the end of January. If you look at the calendar for January, and the court can take judicial notice of that calendar, you will see that there are exactly 2 weeks, 10 days from January 18th to the end of the month. January 18th, you will note, was Martin Luther King's Day. So there are 9 days. As Mr. Shapiro points out, the building department has 25 people. He says there are building inspectors, plumbing inspectors, electrical inspectors, staff, and administrative staff. None of this tells us how many people are at the front desk. Is that the administrative staff? Mr. Shapiro says we didn't prove that it was a building inspector. We have no information that only building inspectors man the front desk. Well, if that were the case, how many building inspectors are there? Certainly, they could have gone and gotten affidavits from the people who were at the desk and over that span of 9 days and told us that, okay, this didn't happen. And then there would have been a question of fact. But what the city says is, look, if we agree that if the court finds that this affidavit is sufficient, then we agree there was no discontinuance. And the argument really devolves to the point that Justice Massing asked me about, which is, what is the significance of the powers test? So the city seems to be not content with the powers test because, as I've pointed out, there is a logical flaw in it in the way that the city is approaching it. Now, I'll also point out that, certainly the city employees were mistaken about whether the moratorium was in effect. We have instances where Monica Lamboy twice represented that the moratorium was in effect. We know that the city filed a document. We have Mr. Parker's affidavit that a city employee cited the moratorium as a reason for not accepting the application. So there's no credibility issue here that is raised that would deter a trial judge from entering summary judgment. And I know in my brief I suggested that the city misrepresented the existence of the moratorium, but given Mr. Shapiro's concession that the city people did believe the moratorium was in effect, I'm reminded of Hanlon's razor, which is never ascribe to evil intent that which can be explained by ignorance or stupidity. So let's give them the benefit of the doubt. Certainly in this particular case, our affidavit was sufficient to establish the one critical fact. That is something Mr. Parker knew from his own personal knowledge, which is, I went to the building department with a completed application. I had plans attached to it, and I tried to file it, and they wouldn't accept it. Now, we also know from the affidavit of Mr. Cohen and the affidavit of Mr. Parker that when they had the meeting in December with the city officials, they presented copies of the plans, and then those plans were eventually finalized in January and reached Mr. Parker in mid-January, which is why he filed them. And there's finally one other point that the city raises, which is, well, why did Mr. Parker suddenly go back and refile the application? And he suggests, and Mr. Shapiro's suggestion is brief, that there's no evidence to support why. Well, there is evidence to support why. Mr. Parker says in his affidavit, I was told by Mr. Cohen to refile the application, and Mr. Cohen's affidavit also states that he told Mr. Parker, upon being informed that the city had rejected the application, to go back and refile it. So with that, I'll conclude because my time is running out. And again, with the humble request that in order to avoid a third trip back over here, this court exercise its discretion, because it is on de novo review, to not only affirm, but to issue the clarifying statement about the powers test. I think it will go a long way to helping resolve zoning cases. And this case has gone on way, way too long. It started in 2010, and we are now in 2021. Thank you.
Okay, well, thank you both. Very interesting case, and we'll take it under advisement and try to get you a decision as soon as possible so you can move along.
Thank you very much.
All right, we are live and on the record.
Thank you, and welcome to the Massachusetts Appeals Court oral argument session for June 3rd, 2021. As you know, this argument is being held on Zoom, and it's simultaneously being live streamed on the Appeals Court YouTube channel. The panel for today is Justice Peter Sachs, Justice Sabita Singh, and myself, Greg Massing. We will follow the same rules and customs as in our physical courtroom, except you may remain seated if you prefer. Once we get going, the session clerk will display a countdown clock where the court insignia is. Each side gets 15 minutes. There's no rebuttal. And in this case, Ms. Evans will go first. You're welcome to use all your time, but there's no penalty if you finish early. And when you are not speaking, we ask you to mute yourself, but to remain on the video so we know you're still present. But at the same time, be mindful that we can see you. So please keep reactions to a minimum because that can be distracting. As always, we've read the briefs and we're familiar with the case. And in fact, if you see us looking away, it's only because your briefs might be on another screen or on a tablet, and we're looking at the case materials. We are still paying attention to you if we're not looking at the screen. So with that, I'll call this case, which is Federal Home Loan Corporation versus Evans, 2020 P496. And Ms. Evans, it's your appeal, so you go first.
Okay, and I could just read what I'd like to say into the record. That would be, I'd appreciate that. Okay. Truth, fairness, and constitutional due process were and continue to be due to me in this alleged suit. The only way this can be done is for this honorable court to grant my request to reverse and vacate the lower court's final order and render judgment in favor of my request for relief. My reply brief, exhibits, and appendix all speaks for themselves. To ensure fairness and justice, we must first agree on the common set of facts, beginning with how this particular appeal came to be. This is an appeal from an order authorized by the single justice of this court pursuant to Mass Rule of Appellate Procedure 15C and Appeals Court Rule 2.02 to this panel of the Appeals Court for review of its final orders for relief. The appellate's brief and supplemental appendix seems to want to make it about something else entirely. The appellate's brief should not be relied on because despite their claims and allegation, they failed to disclose relevant material facts to this panel. For example, the appellate on page 7 of their brief assert that, quote, on April 8, 2016, the housing court entered a default judgment against Evans. What the appellee and their attorneys conveniently failed to disclose to this panel is that there are standing and subject matter jurisdiction issues in the alleged suit. Freddie Mac standing issues became apparent at a May 25th, 2016 hearing where I factually challenged Freddie Mac's prima facie documents, and Freddie Mac's attorney admitted in open court and on the record to the judge that my challenge was factual and that what was written in their foreclosure deed and affidavit was false. Essentially, what Freddie was claiming happened did not happen. And even though it fell to the housing court judge to inquire into Freddie Mac's standing sponte and into the court's own subject matter jurisdiction, the judge did not. If Freddie Mac did not have standing, the housing court was deprived of jurisdiction to hear Freddie Mac's alleged complaint and did not have authority to issue an order, including issue a default judgment against me. A review of the housing court record will show that the judge not only failed her obligation on May 25th to inquire into Freddie Mac's standing and her own subject matter jurisdiction, but it failed at least 3 more times when she was presented with the opportunity to address the matter. On June 1st, 2016, I again raised the issue of Freddie Mac's standing at a purported pretrial conference, and twice more the issue was raised by my attorneys at a July 7, 2016 and August 3rd, 2016 hearings. Each time the judge refused and completely ignored the matter when raised. And since the issue of standing and jurisdiction has never been resolved, it is unclear if the housing court ever had jurisdiction to hear the dispute or to issue a default judgment, as Freddie Mac reports in their brief to this panel. It is settled law that a court must dismiss a suit for lack of subject matter jurisdiction. A de novo review of the housing court records, including audio recordings, are required to resolve the issue of standing and subject matter jurisdiction in this alleged suit. The last thing I'll say on this is comes on page 18, 19, and 20 of Freddie Mac's brief, where they repeat the same false claim, quote, on May 4th, Freddie Mac levied upon its execution for possession of the property, end quote. What Freddie Mac and their attorneys clearly failed to disclose to this panel is that, notwithstanding Freddie Mac's standing issue and the court's subject matter jurisdiction issue, the purported execution Freddie Mac alleged to have had levied upon was void ab initio for a number of reasons, such as: one, Freddie Mac and the housing court violated a federal bankruptcy automatic stay that was in place when Freddie Mac and their attorneys went to the housing court on April 7 to schedule a hearing to take place in less than 7 days to reissue an execution. And
Ms. Evans? I don't want to interrupt your presentation too much, but I wanted to ask just a question or two about what you just said.
Okay.
And we're talking about the May 4th, 2017 levy, was it?
Yes.
So you're contending that the execution was void for various reasons, including the bankruptcy stay and lack of subject matter jurisdiction, but you're not contesting that the levy actually occurred and the house was sold. Is that correct? It happened. You're just saying it happened without proper authority. I just want to get that factually clear.
Yes, I am not alleging that it happened, because if they did not have a valid execution, it could not have happened. It's essentially void. What they did.
Okay. But the house was sold, and you're contesting.
Yeah, as a matter
whether
of law. Yes, as a matter of law, it never occurred.
Yeah.
Is what happens in terms of if they did that.
And one other question: the execution that was issued, as I saw it in the record, not only gave Freddie Mac the possession, but it also awarded them $16,000 and some dollars.
Yes.
Has that been collected? Has Freddie Mac waived its right to collect that? What is the status of that debt that, whether with jurisdiction or not, was adjudicated by the housing court and put into the execution?
Right. It still hasn't. I haven't heard anything about it being waived. It's still pending, and that's part of why this needs to be reviewed in order to get an understanding of not that.
So when Freddie Mac says this case is moot, you say there's at a minimum there's a dispute about the outstanding money judgment.
Exactly. So not only is the execution void, not only was the execution issued during a stay, they also issued it. It was also my constitutional rights are violated again when they scheduled this hearing with Freddie. The housing court scheduled a hearing with Freddie, much like what is before the panel right now. They scheduled a hearing, never notified me of the hearing. When I found out and told them that they need to remove it because it's violating a stay, they did not. In fact, I would just wanted to finish here. It says automatic stay that was in place, and it goes on to say, and two, the housing court, in a pattern of violating Massachusetts court applicable statutes, the rule of law, housing court standing order 1-04, and my constitutional due process right to be heard before any action can be taken against me or issuing a judgment that does not comply with the rules and case law, schedule Freddie Mac's hearing for April 11, 2017. On April 11, 2017, despite my filing 2 motions prior to the hearing in the housing court, alerting the court to the fact that Freddie Mac was under a stay, the first motion was filed on April 7 and the second on April 11, hours before the hearing was scheduled to be held. In fact, when I went to the court, when I went to the housing court to file my second motion to alert the court, the clerk magistrate was so dismissive to me, he put my alert motion on the docket to be heard on April 19th. would not even give me the respect of not acknowledging it. On May 19th of this year, just 2 weeks ago, the federal bankruptcy court judge handed down its order and reaffirmed that there was an automatic stay in place, and acts that taken prior to or on April 7 were a violation of the automatic stay. The order reads in part, the court interprets 362C3 to provide that the automatic stay terminated at 11:59 on April 7, 2017. So any action they took during that time is void. It said the significance of this order is that it proved that there was an automatic stay in place on April 7th, and that I was correct to ask the housing court to take the hearing off the docket before it violated because it violated the stay. But notwithstanding Freddie Mac and the housing court violating the automatic stay, the actions of Freddie Mac and the housing court relates to the appeal before this panel. It illustrates a pattern by the housing court to act without a reference to guiding rules and principle, and violating my constitutional due process right. The housing court scheduled a hearing to take place in less than 7 days, and despite my motions requesting that they remove the hearing from the docket, it was not, because it was not proper. The housing court refused and held a hearing anyway.
Yeah, so I wanted to ask a question about that, if I could. Sure. And I think what gave rise to your motion to the single justice in 2020 to reopen this matter was the fact that the October 26, 2016 order of the single justice was not served upon you. And I'm looking at it in the record, and I see that copies were sent to various attorneys and to the housing court, but your name isn't on there. So I can see how, I want to make sure I understand all the implications of that. I can see how that shortened the time that you would have had to prepare for the November 2nd hearing in the housing court where the use and occupancy order was issued.
Yes.
And that your lack of time to prepare might have contributed to the fact that the court issued that order, what the amount was, and it might also have contributed to the court's denial of the other motions you filed at the time for a new trial, to vacate the default judgment based on newly discovered evidence, and so forth. Is there any other way I'm overlooking in which you were prejudiced by the failure to get served a copy of the single justice's October 26, 2016 order? Or have I summed it up?
In fact, no, that was only part of it. I was prejudiced by not getting that. I was prejudiced by the fact that I was a pro se litigant at the time. And for some reason, the housing court have me sends up to this is why I was prejudiced. The housing court deliberately sent up to the appeals deliberately would not be served with a copy of the order. I was not served with a copy of the order. And even before the housing court received the order from the single justice, they put a hearing on the docket on Thursday,
right, before they had the rubber stamp on it.
And then he puts it in the mail and never notified me.
Yeah, but what I want to understand and make sure I understand is what would have been done differently if you had received that October 26th order at the same time as everybody else did, which I gather for the housing court was October, the rubber stamp's a little faint, but October 31st at 12:54. What would have happened differently if you'd received it then instead of on
so they didn't even
November 1st?
Well, a perfect example, if I received it then, I would at the very least had more time. If I receive an order, I come home at 6:30 on, I think it's a Monday or a Tuesday, I can't remember. I think the hearing was scheduled for Wednesday, and I received a notice on Wednesday at 6:30 p.m. for a hearing that's going to take place at 2 o'clock the next day. I have no way of being able to prepare a motion to be able to speak to what was being presented, because again, I would have made another plea to the court saying, you do not have jurisdiction. Freddie Mac hasn't demonstrated that they have standing. you know, I'm not sure that this case can be heard. So at the very least, I would have been able to do that. And if there was going to be, if there was still going to be a hearing, I would be able to present evidence that I am not a tenant. I'm a former homeowner, and I would be able to speak to that. I would have been able to raise that issue again, because whether or not use and occupancy payment should even have been established against me is still part of what the single justice is still pending in the single justice from the August 18, 2016. When the court received the record, it says right in the notice that, you know, it's not sure if even use and occupancy payment should even been established against me. I've been waiting from August of that year until October, when suddenly a order goes down to remand it back to the housing court. But I'm not sure if there's jurisdiction, and I'm no part of it. They want to have a case without me, and this is what has gone on throughout this. This is what what is before the panel right now, is that this case of essentially taking place without proof of jurisdiction, without proof of standing, and without me being able to send it down. The housing court hadn't even received it. It's stamped October 31st. How are they putting a hearing on the docket, and how are they asking, especially standard rule 104 of the housing court makes clear how you're supposed to treat the self-represented litigant. They knew I was a self-represented litigant, so why would they treat me that way? That's desperate treatment that I'm receiving. Hearing being held without me. Again, the hearing I'm talking about with the execution is the same thing. They held a hearing without me. They issued a void execution, gave it to Freddie Mac. Freddie Mac then claims that they levied up on an execution. It's not clear that they had an execution to levy up on, because if it's void, if what they did without me being able to be heard, constitutional violation right there, to hold hearing without me being present and taking actions against me, and then saying, you just basically got to live with it. This is not fairness. That's not how you treat a self-represented litigant. And this was brought up by the Supreme Court in the case that we had at the Supreme Court level, which it detailed how you're supposed to, at the very least, treat self-represented litigants in court. Allow them. But that's pretty much it. They scheduled a hearing, held a hearing,
Ms. Evans,
and issued an invalid execution.
Ms. Evans, your time is expired. Let me see if there's any other questions from the panel, but I think we'll have to go on to hear from the other side.
Thank you. Thank you, Ron.
Justice Sachs, Justice Singh? Okay, hearing none, we'll hear from Attorney Linehan.
Good afternoon, Your Honors, and may it please the court, Brian Linehan for Federal Home Loan Mortgage Corporation. To address some of the points that Ms. Evans made at the outset, first of all, the bankruptcy court order that came down a few weeks ago, that was on a motion to dismiss. Ms. Evans survived that motion to dismiss, so there were no actual findings aside from the fact that the automatic stay terminated on April 7th, but those issues are being resolved in the bankruptcy court. They're not before this court. They weren't mentioned in the briefs. They weren't mentioned in the motions to the single justice. Second, the housing court proceedings have been reviewed by the Supreme Judicial Court, and all of these arguments were made in Ms. Evans' briefs in her prior action to both the Chapter 211, Section 3 petition to the Supreme Judicial Court and the appeal therefrom. The Supreme Judicial Court did reject those arguments, finding that Ms. Evans could have raised them in a direct appeal from the judgment or the order on her motion to vacate the judgment, but she did not do so. So those issues have been considered and rejected by the Supreme Judicial Court. With respect to the underlying housing court proceedings, they are not properly before this court for review. A bit of procedural history is necessary to clarify, but default judgment entered against Ms. Evans on June 9th, 2016. The trial was held the prior day on June 8th, 2016. I think we understand that. We understand how this got to the single justice, but can you address the lack of notice and the one-day hearing from the single justice? Certainly. So first, Ms. Evans in her briefs concedes that she did receive that notice from the housing court scheduling the use and occupancy hearing for November 2nd. I do understand that she says that she received that the day before and she did not have enough time to prepare. However, there is nothing on the notice of docket entry from the single justice session, which is in dispute here, that would indicate that the hearing was going to be held on November 2nd. The only thing that that notice of docket entry says is that the recipient is to consult the docket for the full text of the court's order remanding the matter to the housing court.
Well, can I stop you there and get some clarification? I'm looking at Record Appendix 33, which is the notice of the October 26th 2016 order on paper number 6.
Certainly.
And what it says is see order of 10/26/16, which was that date, on paper number 8. So is there, and I couldn't find in the record where the notice of docket entry on paper number 8 was. Is there anything in the record besides the docket itself which shows the order on paper number 8? Was a similar notice like what we see at Record Appendix 33 regarding paper number 6 sent out regarding paper number 8?
No, Your Honor, there was no written order issued to the parties on this. This notice of docket entry was the order informing the recipients to consult the docket for the full text. There was no separate written order issued in that case. Now, even if Ms. Evans did not receive that notice of docket entry, the single justice docket is publicly available online. And Ms. Evans has attached printouts of that docket to numerous filings in the Housing Court, the Supreme Judicial Court, and this court. So we know she has access to that docket. So to the extent that she's alleging that this is newly discovered evidence, this notice of docket entry, she can establish that she would not have been able to discover the evidence earlier had she not diligently reviewed the docket. Like I said, this notice of docket entry does not contain any substantive information. It doesn't contain the date of the use and occupancy hearing, the time. It doesn't say that the matter is being remanded. It simply instructs the recipient to consult the docket. Now, with respect to the notice—
But at least that would have alerted her that she should consult the docket to see the ruling on paper number 8, which in turn would have alerted her that the single justice was instructing the housing court to hold a use and occupancy hearing.
Certainly, but it did, like I said, that did not provide the actual date of the use and occupancy hearing, and the timing and the notice with respect to the use and occupancy hearing are essential here, because what Ms. Evans did not point out when she was arguing is that she appeared in the courthouse on November 2nd on that morning. She was there the day of the hearing. She says she received the advance notice. She appeared in the courthouse. She filed a motion to continue and a request for an accommodation under the Americans with Disabilities Act. And then she left the courthouse before the matter was called before the judge. Now that's important because there were several other motions that Ms. Evans filed in the housing court prior to the use and occupancy hearing, where she requested continuances, she requested reasonable accommodations and other relief, and left the courthouse before the case was called, and those motions were denied for lack of prosecution. So she should have known that if she failed to present her argument when the case was called before the judge, the motion to continue would be denied for lack of prosecution. She had the opportunity to argue to the housing court judge that she did not have adequate time to prepare for the use and occupancy hearing and request a continuance to allow her to do so. She failed to press her motion to continue at the time the case was called on November 2nd, 2016. So the housing court judge was well within her discretion to deny that motion for lack of prosecution. And like I said, this is not the first time that this has happened. The default judgment occurred in the same manner. Ms. Evans appeared on the day of the trial. She filed a motion to continue the trial and then left the courthouse before the case was called. So the motion was denied for lack of prosecution. So to the extent that Ms. Evans is arguing that her due process rights have been violated, she had notice and she had the opportunity to be heard, even if on a simple continuance, motion to continue to allow for more time for her to prepare. Now, the notice issue is also important because Ms. Evans files her motion to the single justice under Rule 60, 60A and 60B. But Rule 60 cannot be used as a substitute for the normal appellate process. And with respect to the notice for newly discovered evidence, I'm sorry, the request for relief for newly discovered evidence, the Sullivan versus Smith decision, which is cited in the brief, says that relief under Rule 60 is not available for lack of written notice where the party has actual notice of the hearing and fails to take appropriate action. And that's what happened here. Now, the other reason that this case is not properly before this court is because Ms. Evans filed her motions in the single justice review session. But the single justice's jurisdiction under Chapter 239, Section 5, with respect to that session, is limited to the review of the appeal bond that was set by the housing court with respect to Ms. Evans' appeal of the order denying her motion to vacate the judgment. The single justice does not have the jurisdiction to conduct an independent de novo review of the underlying housing court proceedings. As I mentioned, Rule 60B cannot be used as a substitute for the formal appellate process. And that's
So the single justice's jurisdiction would encompass a review of the use and occupancy order.
correct, but not, as Ms. Evans argues, a full de novo review of the underlying housing.
Okay, all right. So when you assert that the case is moot, you're not saying that there isn't still a dispute over whether she owes Freddie Mac $16,000. You're just saying that because of the limited jurisdiction of the single justice, that issue was not before him, and therefore it's not before us?
Well, that is one aspect of the argument, but that goes more to the court's subject matter jurisdiction. The appeal is moot because Ms. Evans was physically evicted from the property, even if she contends that that was unauthorized. She was removed from the property, and Freddie Mac did sell the property. Now, the housing court only has subject matter jurisdiction in a summary process action to the extent that there is a claim for possession. But because neither party now has a claim for possession, even if the underlying housing court proceedings were reopened, the housing court no longer has jurisdiction to entertain that dispute.
But doesn't it have jurisdiction to enforce the monetary portion of its judgment?
It would, to the extent that Freddie Mac is seeking to enforce that judgment, but I have not been instructed to take any action on the judgment. To my knowledge.
But as long as the judgment and indeed the execution, it appears to me, are outstanding, there's still a live dispute, whether it's before us or not, about that 16,000 and some dollars. So the dispute as a whole, the case as a whole is not moot, even if the possession issue, in your view, is moot.
I understand.
Sorry.
But to that end, Your Honor, Ms. Evans does not mention the monetary judgment in her briefing. She is only speaking about the underlying eviction of the property, the judgment and the execution that issued. Not mention the monetary relief granted anywhere in her briefing or in the motions to the single justice. Now, in addition, the underlying claim for relief under Rule 60B2 for newly discovered evidence, as I mentioned, Ms. Evans cannot demonstrate that alleged newly discovered evidence, being the notice of docket entry, could not have been discovered earlier through diligence if she monitored the publicly available online docket. She can't demonstrate that the evidence is not merely cumulative. As I mentioned, the notice simply instructs her to consult, or the recipient to consult, the online docket. And she cannot demonstrate that the outcome of the hearing would have changed. She left before her motion to continue is argued. That has no bearing on whether or not, or the outcome of that motion is not affected by whether or not she received that notice of docket entry. This is nothing of substance in that notice. She should have informed the court once the case was called that she just received notice the day before and that she was requesting a continuance, and advanced her motion once the case was before the judge, and she failed to do so. She left. So that outcome, she cannot demonstrate that the outcome would have changed. And that's why this Sullivan versus Smith decision is important, because in this case, she did have actual notice and she failed to take appropriate action when the case was called. Now, with respect to the underlying housing court proceedings, those proceedings aren't properly before the court because, like I mentioned, the motions were filed in the single justice appeal bond review session, but that session is limited to the review of the bond. But to the extent that the court would like to address those issues, I can address them here. Now,
I have a question related to what's before us on the appeal bond.
Sure.
In August, I think, of 2016, the single justice issued a 2-paragraph order canceling a hearing that had been scheduled for the next day and saying that there was some doubt about whether this was actually a proper appeal bond waiver appeal. Since then, the case of Bank of New York Mellon versus King has been decided. That makes clear, I think, that in post-foreclosure eviction proceedings, use and occupancy payments can be ordered. So if that had been decided at the time, would there still have been the uncertainty over whether this was a proper appeal bond waiver appeal to the single justice?
So that's it's got two issues built in there. So the appeal bond review, initially the housing court judge entered an appeal bond and required Ms. Evans to make monthly use and occupancy payments. The appeal bond was for the past due use and occupancy through that date, if I recall correctly. When Ms. Evans sought review under Chapter 239, Section 5, the single justice came down and said that the appeal bond was improper because she was not appealing the judgment against her. She was appealing the order that denied her motion to vacate the judgment. And because the judgment wasn't on appeal, they said that the appeal bond was not proper under Chapter 239, Section 5. But they did remand the matter to the Housing Court for the use and occupancy hearing. And as Your Honor mentions in the King decision, the court does mention that even if the appeal bond is waived, the Housing Court can still enter an order requiring monthly use and occupancy payments. Now, if Ms. Evans did in fact wish to further challenge that use and occupancy order, under the statute, she was required to seek further review from the single justice within 6 days of that order. That is actually referenced in one of the single justice orders on her recent motions. She failed to do so. So to the extent that she seeks review of the use and occupancy order, her motion is untimely. Now, as I mentioned, with respect to the motion to continue, the request for an accommodation in the Housing Court and the Housing Court order itself, even if those arguments were still meritorious, notwithstanding the fact that the eviction has been completed and Freddie Mac has sold the property, even if there were some argument, Ms. Evans had the opportunity to appeal, to raise those issues in the appeal from her order on the motion to vacate. But she did not make the use and occupancy payments, she did not seek further review of that order, and her appeal was dismissed for failure to make the payments. She cannot use Rule 60B as a substitute for the normal appellate process to unwind that default judgment or the use and occupancy proceedings. She was required to follow the normal appellate process, which was addressed by the Supreme Judicial Court in the decision that issued in April of 2019. They said that she had an adequate alternative remedy in the form of a direct appeal, both with respect to her request for an accommodation of the Americans with Disabilities Act, and also with respect to the motion to vacate the default judgment and the orders on her motion to continue. She could have advanced those arguments in her appeal. She failed to do so. She failed to prosecute her appeal, and it was dismissed for failure to make the use and occupancy payments. Nevertheless, as I mentioned, the motion to continue was denied because she failed to advance the arguments when the case was called before the judge. She left the courthouse. So the judge was well within her discretion to deny the motion for lack of prosecution. Same thing with the request for an accommodation under the ADA. Under the ADA, if a request for a reasonable accommodation is made, the court should conduct a hearing to resolve any disputes, determine the reasonableness of the request, and to determine whether there are adequate accommodations that may reduce the burden on the parties. Ms. Evans did not appear for the hearing on the request for reasonable accommodations, so the judge denied that for lack of prosecution as well, because it was unable to conduct a hearing on the merits on the request. And that process is outlined in the Ajari decision issued in 2019 from the Supreme Judicial Court as well. And as I mentioned, with respect to the constitutional allegations, the use and occupancy hearing did not deprive her of due process because she had actual notice and a reasonable opportunity to be heard in defense. And I see my time is running out, so if there are no further arguments, questions, I will rest on the briefs.
Seeing none, thank you both for your argument.
We are live and on the record.
Great, thank you. Good afternoon, and welcome to the Massachusetts Appeals Court oral argument session for June 3rd, 2021. It's the last argument of the day for us. As you know, it's being held on Zoom and live streamed simultaneously on the Appeals Court YouTube channel. The panel today is Justice Peter Sachs, Justice Sabita Singh, and myself, Greg Massing. We'll follow the same rules and customs as in the physical courtroom, except feel free to remain seated while you're speaking. Once we get going, the session clerk will display a countdown clock where you see the scales and the appeals court's insignia. Each side gets 15 minutes, although I understand that the appellees are splitting their time 50-50. You're welcome to use all your time, but there's no penalty for finishing early. And when you're not speaking, we ask you to stay on the screen so we can see you, but mute yourself. And but at the same time, since you're on the screen, we can still see you. Remember that, and please keep any reactions or gesticulations to a minimum, because that can be distracting. The proceeding is being recorded and archived and will be accessible to the public. And as you know, this is an impounded case, so please don't refer to the father or the children by name. Use use descriptions. And as always, we've read your briefs. We're familiar with the case, so you could just get right into it. And if you see us looking away, it's not that we're distracted, it's that we actually have your materials on our tablets and other screens, and that's what we're looking at. So, for example, right now, when I call the case, I'm looking at a different screen, 2020 P 806, which is Department of Children and Families versus Father. And we'll hear from Attorney Diaz.
Thank you. Good afternoon, Your Honors. May it please the court, Myrna Diaz on behalf of Father, appellant in this matter. Your Honor, Father is seeking a reversal of the lower court's termination of his parental rights. Father concedes that he is unfit and was unfit at the time of the trial. Father, during the pendency of the case and the trial itself, did put forward a plan along with mother, who unfortunately passed away in October of 2020, which is why it is just father in this matter. The family had proposed a plan for a guardianship to be put into place, a permanent guardianship with paternal aunt. And that is where the child resides to this day and has resided for the past 6 years. So since the beginning, Father, once he realized that he was going to be unable to care for his child, the child was born 7 weeks premature. And at the time of her birth, the parents unfortunately were not prepared. They were homeless and did not have the basic necessities that were going to be required. So Father did reach out to his sister, the paternal aunt in this case, and asked her if she would be able to become the child's custodian. Obviously, the department did step in, and that is where the child has been placed since that time. Father is seeking a reversal of the termination of his parental rights. He was in agreement and is still in agreement with the child being in a guardianship with his sister. And that is what we are seeking that the court do today.
Can I ask, what's the practical difference between adoption and a permanent guardianship?
Well, Your Honor, in an adoption and the termination, the severing of the parental rights, which is what took place here, it doesn't allow Father to have meaningful access to his child. With a guardianship in place, it would have allowed for Father to still have meaningful access to his daughter and continue to have a relationship with her. Once the parental rights are terminated, and as you can see from the lower court's decision, the court also did not order any post-termination visitation between father and child. So the difference would be that the family would be kept together. It would be kept as a whole. The integrity of this family would continue. And that is essentially what the difference would be, Your Honor.
But aren't they on good terms? I mean, this is his own sister. Was there any indication that that she would not accommodate him?
That is correct, Your Honor. They are on good terms, and they do get along well. The issue here, Your Honor, is that the juvenile courts, it can't, it's against public policy to break families apart. And the message that is being sent here is that the minute that a parent is found to be unfit, then those rights should be terminated, and that's not what the juvenile court should do, or any court for that matter. So being able to still have his parental rights to his child and keep the family as a whole is what Father is essentially seeking.
So the judge, in ruling on post-termination visitation and deciding not to order it, found that there was no evidence of any bond or attachment between the child and the father. So how would guardianship be better for the child than a termination of parental rights?
Yes. So in the record, Your Honor, it does state that there the parents, well, sorry, the father in this case, he did have, during the pendency of this proceeding, he did have visits with his daughter. Most of those visits were supervised in either a DCF office or under the, the direction of a DCF worker, either at a park or inside of a building, essentially. But him being able to, he does have a bond with his daughter. His daughter does know who he is. At the end of this case, the child was 4. She did have many visits with the child, with his daughter. And even post-case, there have been visits between father and child. So that bond is there. And Your Honor is correct. It does state in the record that the minor child did appear to have a bond with the paternal aunt. And that's obviously because that is someone that she does see on a daily basis. So that bond is, thankfully that bond is there between the child and the paternal aunt.
I mean, you argue that you concede unfitness.
Yes.
And the judge found there's clear and convincing evidence that the unfitness is likely to go on indefinitely.
Yes.
And do you except for the reasonable accommodations, do you contest that at all?
The reasonable accommodations. So
no, except for that, I mean, do you have any argument that any of the judge's findings that he's unlikely to become fit in the future are clearly erroneous or abuse of discretion?
No, Your Honor, I do not. Again, we're not saying that father, the judge was correct in her termination that he was unfit. What father is trying to argue is that he had a plan and DCF had a plan, and DCF's plan was not too far off from his plan. So what we're saying is that the court should have considered father's plan of having a permanent guardianship be put into place, which was actually the first judge who presided over the case in the trial court. Also at the beginning of this case did suggest that a guardianship should be put into place. And that was, then the case went on for 4 years. So had this been something that had been done at the beginning, perhaps the department could have assisted this family with distance parenting and putting the guardianship into place and showing the family how this could be something that could be worked. So that's another kind of thing that the court should have considered at the time, is allowing the permanent guardianship to be put into place, allowing this father to work with his sister to, continue to bond with his child, as opposed to going forward 4 years later and completely terminating his rights. The visits may have been different as well, as opposed to being in a DCF office. It could have been a different type of bonding that could have taken place between the father and his daughter.
May I ask about another potential difference between guardianship and termination of parental rights and potential adoption? And correct me if I'm wrong, but a guardian can come to the court and say, I don't want to be the guardian anymore. I can't be the guardian. I can't manage this. In essence, resign. Whereas it's harder for a parent to do that if a parent has adopted a child. So in terms of permanency, we don't want to suggest that where the record doesn't support it, that there's any ambivalence or doubt on the part of the father's sister. But if frustrations and difficulties built up in the future, if she were only a guardian, it might be easier for her to say, I can't do this anymore, than if she had adopted the child. So doesn't adoption provide more permanence in that sense?
Your Honor is correct. A guardian can walk into court and, and resign and say, I can't do this anymore. However, there's nothing in the record that states that this particular aunt was going to be doing that. She's committed to working with, raising this child, and also, having father be a part of that as much as possible.
Yeah. Did she express a preference, the aunt? I know you said in your brief that she said she would be willing to, that she could live with a guardianship. but I didn't see, or if I saw it, I missed it, a reference to any submission by her, testimony, affidavit, statement to DCF, anything else about what her preference was.
Yes, so there was a part, there was a time during the trial where the trial counsel for father had attempted to submit guardianship paperwork, but it was not accepted by the court. And unfortunately, that was not part of the record, but it was discussed.
Yeah, I saw that discussion, but that appeared to be after an uncounseled discussion with the sister. And so the sister didn't necessarily express a preference in that situation for guardianship over adoption. That was an indication that she, at least without having been advised of all of the legal differences, was willing to go along with adoption or with guardianship. Is that accurate?
Yes, Your Honor. So that is what my understanding as well that happened during the pendency of the case, is that there was paperwork attempted to be submitted, but then never went forward. And then I do understand that the aunt did testify that she'd be willing to adopt the child. So yes.
Do you remember where that is in the record, where the aunt testified that she'd be willing to adopt?
I do not, Your Honor. I apologize. If there are no more questions, I would just ask again on behalf of father to reverse the termination decree by the lower court terminating father's rights. Thank you very much.
Being none, thank you. We'll hear from the department.
May it please the court, Adelaida Jaspers for the Department of Children and Families. The department respectfully asks this court to affirm the decision of the trial court in all respects. This is a particularly sad case where, despite the department's concerted efforts and reasonable accommodations tailored to father's special needs, he was unable to make adequate progress and lacked any insight into the child's complex needs. He refused to cooperate with the department and service providers, and he did not engage in most services. All these factors contributed to his unfitness, to which he concedes, and where the evidence showed that there was no reasonable likelihood that father would become fit, it was proper for the judge to terminate his parental rights because the child is entitled to and deserves permanency, stability, safety, and security that father unfortunately could not provide. I'd like to address a couple of points. First, I'd like to explain why adoption was proper in this case. And then I'd like to talk about reasonable efforts, if any questions that this court might have, perhaps regarding post-adoption visits as well. Here, the plan of adoption best serves the best interest of the child and would provide her with the type of permanency that she deserves, which is critical in light of her global developmental delays and the fact that she needs a caregiver who not only understands her complex needs, but also provides for her and advocates on her behalf on a consistent, ongoing basis. The adoption allows the child to have the lasting permanency, and if not, the father would have the right to petition the court every 6 months, which would undermine the child's permanency. In addition, as Justice Sachs pointed out, there is a likelihood in the future, we don't know the future, but the guardianship or paternal aunt could resign at a future point, and that does not constitute permanency for this child with medical needs, complex medical needs. In addition, father concedes, as I said, to his unfitness and to his termination now, and does not dispute any of the court's 152 detailed and specific findings. The father had 4 years at his disposal and had provision of services that were designed were designed according to his needs, and he did not show any appreciable gains. In addition, he displayed an uncooperative behavior and a pattern of resisting most efforts to assist him with his shortcomings.
Counsel, can I just ask you, I mean, you know, we've heard from father that they're not contesting, you know, fitness, and even to this day. So if you could, if I'd like to focus you more on the guardianship versus adoption issue. There are cases where guardianship is the ultimate determination and is determined to be in the best interests of the child. Why doesn't this case fall into that kind of a scenario? Isn't this the perfect scenario where the father and the guardian, from all accounts, have an amicable history? He's, you know, his situation of living in a car, homelessness, all his other issues put him in a position where he can't physically provide those physical needs, the material needs for the child, but he could still be a part of the child's life because this is his own sister taking care of the child. Why isn't the scenario where a guardianship would be the best scenario?
This is not that scenario, nor for a series of reasons. And just to quickly address the point that he would still have contact with the child because the paternal aunt testified that she would provide those visits and would allow contact and facilitate. So, and I alluded to some of the reasons why the guardianship would not be an appropriate vehicle in this case. And a salient factor is the child's critical medical needs. The child has global developmental needs, and the court found that she, and based on testimonial evidence, that she would require a caregiver who can provide for her and advocate for her access to services throughout her childhood, perhaps into adulthood.
And the guardian would do that?
A guardian would do that. However, the guardian would have to be, for any kind of certain medical decisions, the guardian would go before the court to seek permission. There are yearly court discussions. In addition, the reason that I mentioned earlier, which Justice Sachs pointed out, the likelihood of declining in the future. This is not a child who, given the child's complex needs, this child requires this level of stability. And in addition to that, this child would have that contact, the post-adoption contact, because of the kinship relationship. So whereas guardianship would have been in the best interest of the father, the guardianship is not in the best interest of the child. And once termination has been determined, and in this case also conceded, the decision about the plan is entirely in the discretion of the court, and it represents the court with the most quintessential discretionary decisions to which a great deal of deference must be afforded. So the adoption is the appropriate plan for the child in light of all the factors that I mentioned, in light of the child's needs, in light of the fact that guardianship does not provide that type of permanency and stability that this child needs. And I think my time is expiring. So if there are no further questions, I would like to conclude by asking this court to affirm the decision of the trial court, and this child deserves, as entitled to permanency and stability, which would be eased by father's termination of parental rights. Thank you.
Thank you. I see Attorney Unger is already unmuted and ready, so.
Well, good afternoon, Your Honor. As you mentioned, I'm Attorney Unger, and it is my privilege to represent the child in this case. So there's been a lot of attention here on the differences. It seems like the perception might be minor differences between guardianship and adoption in terms of the practical day-to-day differences. But that's not true, because ultimately it is better for the child here if the buck stops with the aunt. In other words, she needs a parent here. She needs a permanent, everyday parent. She doesn't need a guardian here. And it's not just a matter of minor inconveniences. It's a matter of having to get DCF's permission every time a medical thing comes up. things like travel to visit family. She's already going through great lengths to make sure that this child's best interests are served, and having it be a guardianship versus an adoption just adds another layer, another burden to this
So
aunt.
why wouldn't that be the case in every case? In every scenario, adoption would always be the preferred. Is that what you're saying? Adoption is always in every scenario, in every case.
I think given circumstances like these, yes, Your Honor, it's preferable. Now that might be different in a case where there were a strong bond between the parent and the child. That might be different in a case where there was any evidence that the parent would someday become fit. But in this case, where there was literally no evidence presented, and Attorney Diaz concedes that father's just not going to be a fit parent. There's no evidence that there's a bond, and there's every bit of evidence that this aunt will do whatever it takes, in her words, to take care of this child. Then adoption is better. Adoption serves the best interests of this child. Seems like there's no contest that there is a good relationship between the siblings here, between father and the aunt. But the fact that she would be the adoptive mother would allow her, as she's the boots on the ground here, and she needs to be the one to make the call. Okay, are visits still serving the best interests of this child? I'm not implying that she would cut these off, but for example, visits between father and this child, while generally positive in terms of father's attitude toward the child, they haven't always gone that well. There have been times when the child behaves inappropriately, and then father reacts inappropriately, either by ignoring the child's inappropriate behavior or laughing, essentially encouraging it. There are times when he has ignored the child's safety needs during visits. When she runs off to traffic and just ignoring this, there have been times when it seems that he has exacerbated a safety situation. DCF says, the social worker says, don't pick her up. She's throwing a tantrum. If you pick her up, she's going to throw herself backwards and fall. And father ignores DCF and does this. So it will be better for the child if it is in the aunt's hands, if it is in her discretion to handle whether or not visits are appropriate. And I know that Attorney Diaz claims that this sends a message that the minute parental rights are terminated, that's it in terms of visitation. But that's not true. This is this decision is based on the facts of this case, and in this case, adoption will be better for this child. There is a question, forgive me, I forget if it was Justice Massing, about whether or not the aunt had expressed a preference for adoption versus guardianship. And if you look at her testimony from I think June 20th, where she's talking about this, she never explicitly says, I would rather adopt than be the guardian. But everything that she says that she would want, I want permanency. I would like to stop the visits of DCF, coming in and out of my home all the time. I had to switch to a night shift so that I could accommodate these visits. I don't care what you call it. I really just want to take care of her, and I'll do whatever it takes. So even though she doesn't literally say, I want adoption and not guardianship, if you look at what she's saying she wants, that is her message loud and clear. And that's been her message since fairly early on in the case. Originally, she really hadn't cared. She wanted to give her, oh, sorry.
I have to say, I'm looking at her testimony now, transcript 1488. She says she wouldn't have a problem with accepting the role as an adoptive mom, but she's always wanted to give her brother and his wife, late wife now, a chance to get themselves together to see if they can find housing. And she's made that position very clear. So it seems like she was expressing a preference for guardianship at that point.
I think if you take her testimony as a whole, Your Honor, she's expressing how she wanted to give her brother a chance. Her brother had that chance and did not make the most of it. He had the opportunity to work with a parenting aide to get housing. He had the opportunity to sign that lease and declined because he didn't want to give DCF a key. So in terms of housing, there was no progress. The aunt saw this. She saw he had a chance to get housing. He had many chances to get housing, and he didn't. He had a chance, many chances to get his act together, and he didn't. And she wants permanency for this child, and permanency is what this child deserves. I would be happy to answer further questions from the panel. Otherwise, I'm also happy to rest on my brief.
Well, I just, I'm trying to tease out this distinction, and in some cases that determination is made that guardianship is the best situation, the best result. And what I heard a lot from counsel was that guardianship is burdensome for the guardian. And for a lot of those reasons, adoption is better. There's fewer things that the guardian needs to do, get permissions from other people. It's less disruptive to them. So I was trying to focus more on how does it, from the child's point of view, how is there really any difference of this person being their permanent guardian versus their parent?
It's in the title itself, the fact that adoption is by definition permanent. Father wouldn't have the opportunity every 6 months to go back into court and contest this.
But this is a case where there's no indication that father would do anything of the sort. This is the result he wanted.
For now, Your Honor, that's true. But if this were dragged back into court, who's to say what could happen in the future? And with it in mind that the court's job was to ensure security and stability for this child into the future, adoption is the way to do it and not to leave her in limbo. Thank you.
All right, well, thank you all for your arguments. We'll take the case under advisement, and as I've been promising everybody, we'll get you a decision as soon as we can. And so have a good afternoon, and that'll end this session for today. And I want to thank Mr. Gesling for his help.